English works are published yesterday by Gokhale Institute. They run into 11 volumes in English. Yes, on varieties of subjects. Yes.
Number 10, madam.
Will accept notice, my lord, in this.
Shri.
It's coming.
So and so.
Madhusudan UA.
My lord, serial number
Yes.
10, 19 and 20 are all same questions of law.
10,
19
19,
and 20.
20.
Yes. The questions of law is such that my lord, the section 12B4 has been invoked. Because 12B4 has been substituted for the earlier provisions.
For the earlier,
For earlier, in place of earlier provision, the section 12B4 has been substituted with effect from 1/4/21, 1/4/22.
1422.
22, but it is a substitution. So the commissioner has invoked the provision to cancel the registration under 12AA.
Is it with retrospective effect?
Yes, because it is a substitution, we are,
Substitution, when a date is fixed, the commissioner
fixed.
cannot go beyond the date.
but then we have to invoke a provision. So therefore, this is the procedural provision. This is a procedural to cancel the registration.
The law is all substantive amendments are prospective in operation.
Yes,
All procedural amendments are retrospective
Yes.
in operation
Yes.
unless the law otherwise says.
Yes.
In this date is fixed.
yes.
That
So-
beyond that date you cannot go. That's the law.
We have raised the question because
But
and the other way to look at it is, even if it is held that the section cannot be invoked retrospectively, for prospectively, at least the cancellation should be workable for the prospective period from the date of cancellation. I am taking the file and lordship has taken.
My lord,
how courts have,
serial number 19 will take note, file vakalat, my lord.
ಅಲ್ಲ
Take
ನೋಡ್ತಾರೆ
the note.
ಮೊದ್ಲಿಗೆ ನಮ್ ಕನ್ವಿನ್ಸ್ ಆಗ್ಬೇಕಲ್ಲ admissioning. It's a substantial question of law. Your role comes only after we do something here.
We don't have file also.
ಯಾವ with effect from which date you have cancelled?
1/4/21, my lord.
Page 21.
Questions of law at page 12. The tribunal's order is there at page, starts at page 15.
How the tribunal has
31.
reasoned?
The Tribunal says that the section 12B4 (2), which is a procedural provision for cancellation of registration by the commissioner.
Procedural
The-
power to cancel is never held as procedural.
Then it has to be applied, it has to be implemented from the date of the alternative submission, it has to be implemented from the date of the order.
No, where you pass an order
Yes.
saying that it will be effective from the date Babur had come to India. But you have power to effect severance after advent of the freedom. You can't say the earlier period may be ignored and the rest period may be held
That
valid.
is a question of to be,
That's the question answer.
that's the question to be considered.
No, we are considered now. Where is that? Any standard book on interpretation? Like Grace, Crawford, Sutherland, Maxwell, G.P. Singh.
If it is proved, the tribunal has not gone into the merits of the matter to see whether they have violated the provisions of the act.
Now, you
To
show the
Invoke
power.
cancellation.
You show the power to cancel registration in all civilized jurisdiction is treated as substantive power. How it should be effected is procedural. Notice kodabeku.
Yeah, that is,
That is procedural.
yeah.
But power to cancel as such, the courts have said under the Society Registration Act, that it's a substantive power.
Yeah, my lord, if a lordship takes 12B4, it is more of a procedural issue. what it says is 12B4(2), in certain circumstances, in so and so circumstances, what does it say? It says pass an order in writing cancelling the registration of such trust or institution after affording a reasonable opportunity of being heard for such previous year and all subsequent previous years if he is satisfied that one or more specified violations have taken place.
Why do you say it is procedural? What is the basis? Which law to be called as procedural? Which law to be called as substantive? Any law whose operation per se violates your substantive rights is substantive law. Procedural ಅಂದ್ರೆ adjective law, evidence, limitation, ಇಂಥದ್ದಿದೆಯಲ್ಲ ಅದನ್ನ procedural ಅಂತ. Procedure relating to procedure as such, which is adjective.
Procedure, it starts with 12AB, starts with procedure for fresh registration.
That is what title says.
Yeah, no, I'm not very much on that.
That's what.
More on the section, subsection 4. It reads as where registration or provisional registration of a trust or in an institution has been granted under clause A or clause B or clause C of subsection 1 or clause B or of subsection 1 of 12AA, as the case may be, and subsequently the principal commissioner or commissioner has noticed the occurrence of one or more specified violations during any previous year, or the principal commissioner or commissioner has received a reference from the assessing officer under the second proviso to subsection 3 of section 143 of any previous year, or such case has been selected in accordance with the risk management or strategy formulated by the board from time to time for any previous year, the principal commissioner or commissioner shall call for documents, information from the trust or institution or make such inquiry as he thinks necessary in order to satisfy himself about the occurrence or otherwise of any specified violation, pass an order in writing cancelling the registration of such trust after affording a reasonable opportunity of being heard for such previous year and all subsequent previous years. If he is satisfied that one or more specified violations have taken place. This is the main section.
So it's not procedural.
If it is already, violation has already happened, then since the section itself.
Inquiry will be held. Will be given an opportunity of hearing to him. Then he passes cancelling the registration. The cancelling the registration arguably may result into abrogation of the trust itself, at least if not abrogation, because trust can exist without registration, at least to avail the benefits under the provisions of IT Act. That it will not be entitled. Therefore, it is not procedural. It is substantive. How tribunal has treated that? Which is the
Tribunal
paragraph?
has,
Page number 29, man.
29.
you got a copy.
Proceeding number 19. I have a copy.
Point para 6.7 being so we find force in the argument of the AR that in income tax matters law to be applied is a law
in force.
For the assessment year unless otherwise stated implied. In the present case, the PCIT is cancelling the registration granted under 12A, 12AB of the Act with the effect from previous year 2021. Relevant to the assessment year 21-22. In our opinion, the law as stated in the assessment year 21-22 is to be applied and not the law as stood in the assessment year 22-23. Thus, we are of the
6.8 says
Yes.
what I said now.
no retrospective and retrospective cancellation could be made under 12B4(2) of the Act as it has been provided or is seen to have explicitly provided to have a retrospective character or intended. Therefore, without any specific mention of the amended provisions to operate retrospectively, no cancellation for the earlier years could be made. In this regard, so and so judgment is.
Madras High Court has
Madras
said that way. 6.8 will be the reasoning. We are in agreement with the tribunal.
Then we'll do one thing, Milord. Since he has taken notice.
Need not.
No, no.
Don't worry about him.
No.
Convince us.
Yes, understood, Milord.
It's a substantive question of law.
Yes. No, because Raviraj is not there, so I made a big, submitted what is the matter for 19 and 20 for admission. We'll fix a date on next week.
No wasting time like that. You should have told in the beginning that I am not ready. You have argued
we-
whatever Raviraj would have
The
argued.
1920 is for admission. That's why it's.
Therefore we are dismissing it. ಹೌದು ಹಿಂಗೆ ಎಷ್ಟು ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್
Then
ಮಾಡೋದು
it may be
ಸಿಂಪಲ್
passed over. It may be passed over.
ಪಾಸ್ ಓವರ್
Let at least develop.
Number 11, K.R. Krishnamurthy.
Notice to R3 has to be served.
I appear for
I'm
respondent.
seeking for dispensation of notice to R3, my lord, at my risk.
R3.
R3, I'm
Who
filing.
is? Who is he?
It's a company
Ah.
whose assets and liabilities are to be taken over by the respondents. There is a dispute and arbitration is going on. Now the dispute, this petition is filed on the ground that the respondent number 2 has not filed his statement of objection within 90 days. And beyond that, an extension was given by the learned arbitrator with the extending the very commencement of the period of 90 days.
That he could not
Insofar as the R2 is concerned, which is beyond the
competence.
competence of the arbitrator.
May I
That
make
is the
one-
question. So
I-
therefore,
But that
R3 will not be affected in either way order is passed. Whether it is dismissed also, it will not affect its.
then you delete. We will not dispense with notice. You can delete at your option.
Since it is the subject matter of the arbitration, it
Do
may be
not.
necessary to be.
If you want him to be on the cost title, notice has to. If you do not want notice to be issued, we can't do that. As long as he remains on the cost title,
Yeah.
res judicata, such other things will operate. Therefore, you choose to delete him if you want to.
Let me consider that, because the reason is.
Then we don't agree with you.
They
Take-
both are shareholders. Petitioner and respondent both are shareholders of R3.
That's all.
So
Then you
li-
can't say that.
I
May I
have
make
a-
one submission, man.
Ah.
I appear for respondent number 2 in this case, man.
Two.
In the connected matter, I have already filed my reply statement. I'm filing my reply statement in the first matter, man.
But three,
That's in so far as 3 is concerned, I don't represent them before the tribunal.
okay.
also.
ಮತ್ತೆ notice-
Nobody is
That's
representing.
the,
Huh?
Nobody is representing before the tribunal.
the challenge is to the statement of defense filed by me, man, before this honorable court. So that's my.
So that's the only
defense.
point.
I have no objection.
So you're not answering my point.
Yes, understood, my lord.
As long as they are on the cost title,
Yes.
res judicata applies.
Yeah.
Therefore, either you take notice by substituted mode, whatever. Or you take by hand summons, paste it to,
I will take hands.
in addition to taking fresh steps conventionally, comma. Petitioners to take hand summons to the third respondent. Third respondent. And all the service to be effected within 10 days. 10 days, first.
Some date may be fixed. my lord.
Call this matter
Small point for
in the-
consideration.
second week of March, along with WP number,
It's already
Adu idu.
connected.
Adu ಇದು. Entry modern.
In both,
interim orders to continue. Till
may I
then.
make one submission, man. I seek for a date, my that's.
But
the-
second week,
the
we don't
statement
know
of-
because benches are going to be changed.
Right.
Na?
May I request in the first week, my lord?
Any date, let us see. Okay, next.
Please.
Number 12, A.I. Sanmati. By Rajkumar.
Your Lordship.
253 days.
Missing link.
Missing link, which Darwin mentioned,
Pur-
this is different one.
Purnachandra Tejasvi ಅವ್ರದ್ದು.
Missing. ಚಿಕ್ಕ ಪುಸ್ತಕ ಅದು,
ಚಿಕ್ಕ
ಸ್ವಲ್ಪ ದೊಡ್ಡ ಪುಸ್ತಕ ಕೊಡ್ಬೇಕು.
Transfer pricing issues, similar issues are pending, my lord.
All right. ಪಿ ಲಂಕೇಶ್ ಅವರ ಹುಳಿ ಮಾವಿನ ಮರ ಕೊಡಿ.
Please.
Okay. No. ಕೆಳಗೊಂದು ಡಿಲೇ ಕಂಟ್ರೋಲ್.
Scene number 13, A. Sanmati, Narendra Kumar J. Jain.
Either connected matter, your lordship, the earlier matter, it may be admitted, transfer pricing issues are involved.
No. Earlier one, 12 ಇದೆಯಲ್ಲ, admitted on the following substantive principle questions of law. ಕೆಳಗಡೆ note ಹಾಕ್ಬೇಕು. Similar questions are being debated in an ongoing matter. Okay.
Scene number 13, Sanmati,
Your lordship, in this case, connected matter delay is already condoned, my lord, and also it is admitted.
ಇದ್ರಲ್ಲಿ ಬುಕ್ಸ್ ಕೊಡ್ಬೇಕು. ಡಿಲೇ ಇತ್ತು ಅಂದ್ರೆ ಕೊಡೋದೇ, ಹಂಗ ಮಾಡೋದೇ ಇಲ್ಲ ನಾವು.
Yes,
ಲಾ ಅಂಡ್ ಶೇಕ್ಸ್ಪಿಯರ್ ಅಂಡ್ ಲಾ ಕೊಡಿ.
Karnataka Vaibhava ಕೊಡ್ತೀನಿ.
ಕರ್ನಾಟಕ ಗತವೈಭವ,
Yes, madam.
ಆಲೂರು ವೆಂಕಟರಾಯ.
Yes, madam.
ಕಣಬ ಕರ್ನಾಟಕ ಗತವೈಭವ ಬೈ ಆಲೂರು ವೆಂಕಟರಾವ್. 2 ಬುಕ್ ಕೊಡ್ಬೇಕು, ಒಂದು ಇಲ್ಲಿ
Yes.
ಒಂದಲ್ಲಿ. ಓಕೆ. Yes. Delay control.
It may be admitted, connected matter is also admitted, my lord.
No. Admitted on the following substantial questions of law.
Yes, madam.
First off, call this matter along with
485 of 23, my lord.
485 of 23. Wherein similar questions are involved. Yes.
Yes, madam.
scene number 14, A. Sanmati,
Permitted to take notice for the respondent. 14.
14.
14, please.
Got it. Delay condone ಮಾಡೋಣ.
Please, please.
Application allowed, delay condone. Notice. Shri Wheelgold accepts notice for respondent. Opponent. Application seeking condonation of short delay of 78 days is supported by an affidavit. First up, ordinarily in matters like this, delay is usually condoned when it is short like this. First up, no prejudice should be caused to the other side by condonation of delay. First, IA allowed, delay condoned. Next.
for preliminary, scene number 15, Raghuram Kadambi.
Lords, I beg to appear in this matter, my lords, virtually.
Yes, sir.
My lords, the short point in these two writ appeals is that, my lords, there were two amalgamating entities which merged in the petitioner with effect from 1/4/2016. And, my lords, the period concerns assessment year 17-18, which is financial year 16-17. Now, the two amalgamating companies, sir, were directed by the tax officer to deposit advance tax while the scheme of amalgamation was pending before the NCLT. Because our submission was that once the scheme is pending, my estimated tax liability for the year would include the liability of the resultant company, because I'm in the process of getting amalgamated with the present petitioner. Now, dehorse that, the officer passed an order under section 210 saying I'm rejecting your analysis. In response to that,
How
Please.
courts have answered this question? Various high courts have answered
yes,
this
yes.
question.
In fact, Manoj, the right from the Supreme Court, Marshall and Sons, now recent decision of the Supreme Court in Dalmia Cements also, that the amalgamating companies carry on the business as trustees in trust of the amalgamated company. So you have to look at the entire scheme. But Manoj, in this, there is a short point now, it can be disposed of on that. We don't have to go into that jurisprudential aspect. What has happened is I have filed my return of the consolidated accounts. The consolidated accounts have been factored in while passing a draft order then before the DRP and the proceedings are complete. There is no question of me paying the advance tax now for assessment year 16-17 where the assessment is completed. So that's the short point. In fact, on the last day, Malhotra directed me to file an IA with the document showing the assessment has been framed. I have filed that. My learned friend was to take instructions on that, because what has happened is now the jurisdiction was in Delhi. So therefore, they were not able to coordinate. I filed that IA now with all the orders.
Yes.
Lord, it may kindly be take up on another day.
Some other day. Your friend is not ready.
No.
We'll continue the interim order. We'll
Yes,
have
sir.
it in the second week.
Wherever convenient, whenever convenient, Manoj, whenever
Ah.
convenient.
Interim order to continue. Call in the second week of March. Just a point, only short point. Is
No, no,
Very
I-
narrow compass.
Mr. Raviraj is not there today. He specifically said
Ah.
that let it be adjourned.
Ah,
Yeah. Manoj, may then can it be in the third week of March? If
Third
convenient?
week of
Third.
March.
I'm sorry. I'm so
Third.
grateful. I'm so grateful.
Ah.
Grateful.
Arbitration matters, number 16, Sushal Tiwari.
My lord, appearing
Interim
for the
order may kindly
respondent.
be turned.
ah,
Interim order may then be
interim.
My lords, issue of transfer pricing, my lords, on comparables. On all the 5 questions are there, my lords.
Not 5 questions admitted. Talgade, some of these questions are being debated in an ongoing matter. Okay.
Grateful.
Number 17, Sanmati, K.R. Pradeep.
1 and 2 transfer pricing issue, my lord.
1 and 2.
1 and 2 only, my lord.
Okay.
3 and 4 not required.
1 and 2.
1 and 2.
Okay.
Much up.
Talgade, very good.
Number 18, Mohammad Monish Saukar,
Ah,
AGA.
My lord, question of law is raised in page number 18 in this, my lord. Raise 2 question of law in this.
What's that?
My lord, in this case,
So, this is substantial question of law and Allah. Very question of law.
Law.
Alwa.
yes, ma'am.
Very question of law.
Yes.
Not substantial question of law.
Correct, correct.
Anyway,
I'm not able to justify the orders, although I have succeeded at each forum. A short point is, I have gone to a selling dealer. He has told me that yes, I have sold and I have received the payment in cash. I rely on his statement. If I rely on his statement, he's entitled to cross-examine. I'm unable to dispute that proposition. Although there are some old judgments that say there is no vested right to cross-examine. The law in that has evolved, my lords.
ಅವ್ರಿಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಷ್ಟೇ ಬೇಕಿತ್ತ
Yes,
ರಿಮೈಂಡ್ ಮಾಡಿದ್ರೆ ಸಾಕ
yes, ma'am.
at the stage of reassessment,
at the stage of reassessment.
Yes, ma'am.
my lords.
But ಬಟ್ ಕ್ವಶನ್ಸ್ ಆಫ್ ಲಾ ಆ ರೀತಿ ಫ್ರೇಮ್ ಮಾಡಿಲ್ಲ ಅವರು
Madila, but
ಮಾಡಿಲ್ಲ ನಾವ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡ the short question that crops up for consideration. A short question of law. The absence of absence of right to cross-examine. A short question of law, regardless of the oneness ONES framed in the petition would be as to availability of right to cross-examine first. This inarticulately having been answered in the negative, right of cross-examination was denied to the petitioner assessee. First, counsel for the assessee submits that the right of cross-examination right from the days of Socrates is considered to be sacrosanct to the principles of natural justice, and therefore, in the absence of statutory enablement, it could not have been denied. First, broadly agree with this. In as much as even God is said to have given an opportunity of hearing to Adam and Eve before punishing them for eating the proscribed fruit in the Eden garden. First, next paragraph. In the above circumstances, this petition, the question is answered in favor of the assessee, and the impugned order having been set at naught, the matter is remitted for consideration afresh at the stage of
Reassessment.
reassessment. First, all contentions of the parties are kept open. Learn sentence for you. Learned AGA made submission in justification of the impugned order. Next book.
Number 19, YV Raviraj.
ಇದು cancellation.
Cancellation, this and this matter, maybe kindly be taken up tomorrow or day after. But we will also prepare our
Next week ಹಾಕೊಳ್ಳಿ. ಯಾವ್ದು
serial number
10,
10, 19, 20.
ನೋಡಮ್ಮ, call together next week.
That's IFA for 20.
10 and 19.
How to decide whether a law is a substantive law or it is only a procedural law. There is some discussion in two books. One is Salmon's jurisprudence. The other one is limits of jurisprudence determined by Jeremy Bentham. He has discussed what is substantive law, what is procedural, what is criminal law, what is civil law. Very beautiful discussion. You will find that. You bring that material. All right. In addition to that, there are judgments. GP Singh mentions about that. Okay.
What's the date is fixed, madam? Sir?
Next week we are having. Yes.
number 21, YV Raviraj.
transfer price.
21.
Kindly be admitted.
Not a month. Then.
22, yes, Partha Sarthi. Arvind V. Chavan.
The question of law is in page 12, your lordship, 12 and 13. Whereas the similar matter, your lord, similar
Okay.
question of law is got admitted, your lordship.
My lord, regarding the same, but it's a little bit of facts are different assessee, that's all.
But challenging the same issue,
My
your
lord,
lordship.
before my learned friend starts with court's permission, I'd like to make one submission, my lord. My lord, the respondents who have been made party, two respondents, that is the Central Processing Center Bangalore and the Income Tax Officer Ward 1 TPS Tumkur, my lord. Both have been made as clubbed respondent, my lord. That has to be separated. That has to be made respondent number 1 as CPC and the jurisdictional assessing officer, that is ITO, has to be made separate.
Rectify, your
They
lordship.
might could.
I'll rectify.
Learned counsel appearing for the appellant has a rectified description of respondent by separating them. Separating them. All right. What are the questions?
Page 12, your lordship. The issue is relating to late payment for the contribution of PF and ASI, your lordship. Whereas when the intimation order under section 143(1) was issued, your lordship, the jurisdictional high court judgment and even the Supreme Court judgment was very much in favor of the assessee, your lordship.
PF and ESI contribution,
Yes, your lordship. When
not
the,
accessible for income tax?
yes, your lordship, it was accessible when the intimation order was issued, that is in 2019.
Ah.
Alum extraction and Savary Enterprises of our jurisdictional high court judgment, which has been approved by Supreme Court also, your lordship, it was held in favor of the assessee. Subsequently, in checkmate case, your lordship, by Supreme Court, it got reversed and held in favor of the revenue. But my point of submission, Your Lordship, when 143(1) order was issued, the jurisdictional High Court judgment and even the Supreme Court judgment was very much in favor, operative, Your Lordship. And that too, 143(1) order is only for the adjustment, not to disallow the deduction and make the addition, Your Lordship. This 2 point I'm challenging in both the matters, Your Lordship.
Then questions arise. Nodama, admitted on 1, 2, 3. Okay.
Much obliged, Your Lordship.
Jane.
For final hearings, number 23, Balram M. Rao.
Yes.
Wait, please. I'm appearing along with my colleague, Mr. Balram. I come from Hyderabad. All these appeals
Sir,
are under Wealth Tax Act. My lord.
Will Tax Act. Will Tax Act is there even now?
Now it is not there.
It's not there.
It is not.
Okay.
mean,
This
from-
early.
From 15, 16, no, these are for assessment years 2004, 5, 5, 6, 6, 7, 7, 8 in 2 matters.
Okay.
And in one of the matters, 2004, 5, 5, 6, and 6, 7. So totally 11 appeals, my lord, by a common order. This is actually the second round before me, lord,
Okay.
before this honorable court. In the first round, when it came up, a very detailed order has been passed, remanding it on a specific issue with observations and also with a direction that the remand matter may be disposed of, keeping in view all the observations. It was not an
Not
open,
open remand.
not an open remand. In spite of that, the learned
Treat it
tribunal
as
has
open
chosen to
remand.
ignore the directions.
Where is that remanding order?
A remanding order? Yes, my lord. That is at pages in the memo itself,
140.
along with the, from 128 to 148. My lord may kindly take to, this is all my submissions, my lord may kindly take at serial number 24 for today. 24
Number
is
24.
Vide developers.
1, 2, 3.
128,
Both 23, 23.1, 24, all
yes,
same.
all the same. It's a common order. Earlier also, in the first round also, it was a common order. My lord may kindly take from the running page 146. That order starts on page 128.
Relevant is 146.
146 onwards, paragraphs 22 and 23, my lord.
A combined
A
reading.
combined reading of clause 10.1G, clause 13.1, 13.2, and clause A8 of the annexure A, together with the no objection under chapter 20C of the Income Tax Act, and the letter written by Sri Dingda, prima facie demonstrates that the developers did have power to alienate their portion of the property and they had entered into the property. It's a different matter if the project did not progress further. A mere failure of the project does not undo the acts of the parties. Therefore, in our view, the impugned order passed by the ITAT is not sustainable. And in the facts and circumstances of the case, it is just and appropriate for the ITAT to have a relook into the matter in the light of the contents of the Master Development Agreement, NOC issued under Chapter 20C, and the letter written by Sri Dingda. In view of the above, the following order. Appeals are allowed. Orders dated so and so are set aside. This is, C
Matters
is
are
also,
referred to.
matters are referred to the ITAT for fresh consideration in accordance with law in the light of the observations contained in this judgment. in view of the tenor of the first order dated 11th August 2016 passed by the ITAT in MP number so and so, we direct, these also very significant, my lord, we direct that the appeals shall be heard by a different bench other than the members who have heard the miscellaneous petition. I shall submit, my lords, the background to this. Why this court passed such,
May not be necessary.
not necessary. I shall leave it at that. Now, the issue was,
Whether it is an open remand or a restrictive remand.
it is restrictive, is my humble submission, my lord. Because these observations which I have taken, my lord, through in paragraph 22. In that background, it has been clearly held. In our view, the impugned order passed is not sustainable. And in the facts and circumstances, because I shall give the background why it was. What happened was, brief facts to only to this extent at the moment, before I take my lord through the entire gamut of the facts. All these three companies were incorporated in the year 1995 to acquire non-agricultural land and then get them converted into agricultural land, and also to enter into joint development agreement with a developer, which was a subsidiary of ITC Limited. Accordingly, a master development agreement was entered into on 5th December 2000. Before that, in supersession of the earlier development agreement. As part of this, now the entire land was to be handed over. Possession was also handed over. As per clause 4 of the master development agreement, all these companies were to get only 15.3% of the constructed area along with the undivided share, corresponding undivided share in the land. They had a right to get that on completion. And there was no limitation, the time limit was not fixed for the project. Then, urban land, they have ultimately what happened in the year, this was in 5th December 2000. By March 2001, possession was also actually handed over. There is acknowledgement, all that.
No, there is a finding also.
My lord?
There is a finding also in the
Yes,
order.
there is a finding. These findings, based on the findings only, my lord would kindly recall in section 2, clause 47, subclause 5 of Income Tax Act, transfer is defined to include in part performance of any contract when possession is handed over. There is also a transfer for the purpose of capital gains.
That is 53 capital A.
53 capital A of TP Act.
Acted in
53
IT
capital
Act.
A of TP Act 1882, read with this clause. And as per clause 13.2 of this master development agreement, I have handed over and I have committed only to get the clearance for conversion from non-agricultural to agricultural process for the purpose of
Non-agricultural to agriculture.
I'm sorry, agricultural to non-agricultural process. Agriculture to non-agricultural process for the purpose of putting up the STP, software development project, because in the entire area, Whitefield area, of a total extent of 16 acres, 27 guntas, all the three companies put together. Now, when nothing took place right up to 2007, ultimately, and the developer had all the aces in its favor. Apart from handing over possession, I had to hand over everything. Whatever papers put up, I had to sign. There was nothing else to be done by me. And even my share, I have given the power of attorney, once it is developed, to be sold through him, through the developer.
You are landowner.
Originally, I was the landowner, all the three. That is, I purchased by virtue of conveyance deeds during 96 and 98, all these different pieces of land adjacent to each other. Composite area was 26 acres. I'm sorry, 16 acres, 27 guntas, 16.27. I was to get only 15.3% of the constructed area. Meanwhile, as a security deposit, aggregate of 28.88 crore was given to me. which was to be refunded at the time of completion and getting possession of my share 15.3%. These were the conditions, basic conditions apart from others.
That money was by way of a caution money.
Milord,
Why that money was given to you if it were to
As-
be refunded?
as a security deposit, so that there will be some pressure on the developer to complete. It is not the consideration. The clauses I shall take my lord through, which are very clear. And
It's a
then
refundable money.
refundable. Ultimately, when all other areas adjacent to that were being developed, and this was not being developed, I was just questioning the developer, when are you going to complete? He says, no, you can go for court. Go to court if you want specific performance. I had no other option. At that stage, he said, the developer, CIDL, which is 100% subsidiary of ITC, was holding the right to assign to anybody else also, or to transfer. Then they said,
Under the agreement itself.
under the master development agreement. Now, even that, they went back. They said, no, now we will rescind this master development agreement. You will have to convey. As I said, in the year 2007. So,
What was the question to be decided by the authority?
why?
For remand, what was the question to be decided?
The question to be decided was on the jurisdictional issue. Now, this issue, that is, when under the Wealth Tax Act, there is a change in the law from the assessment year 93-94. Till 92-93, it was an inclusive definition. Property of every kind was to be taxable, except for those which are exempted. From 93-94, it became a substantive definition. Absolutely, it means only whatever was listed
They are taxable.
are taxable. Whatever doesn't fall in the list,
Earlier, whatever is not enlisted was taxable.
everything was taxable.
Now, whatever is
Is listed.
enlisted is taxable.
Exactly. Now, my submission was, I raised an additional ground only before the tribunal, not before the lower authorities. All along I was fighting. They said, you are the owner of urban land. Therefore, I was taxed. Initially, I claimed there are two exceptions to the ownership of urban land, where there is a proposal to construct and all that. Initially, I was making my claim under those exceptions. Later on,
Your transaction fell into the transition period, old act and new act.
no,
No.
these are much later.
It's a new
Because-
act only,
Only new act.
new act.
New Act came into force from 93-94, and my transaction took place in the year 2000-2001.
So it's a new act only.
It's a new act only. And then ultimately I was forced to sell the land. That is, it was rescinded first. The master development agreement was rescinded. And immediately a conveyance deed was also put up for me to say that as a settlement. This was arrived at. Same date, it was rescinded and it was handed over for 63 crore. Price fixed by them, which was less than even the guideline value. I had no other option but to sign that. Now, having got that, what I did unwittingly, due to some guidance, whatever I got from the professionals, I declared capital gains, long-term capital gains on the amount. Filed income tax return. When the income tax return was filed, and I had paid advance tax also, because that rescinding took place in July 2007. For assessment year 2008-9, during financial year 2007-8, I have paid advance tax also, installment. Now, after receiving so much advance tax, they got up, the department woke up, they conducted a survey. They impounded all the documents. Then all these assessments were reopened. Wealth tax. I have not filed any wealth tax return because I was not assessable. Now, there also, one important factor is this honorable court in the year 2011 and 12 decided in the case of Dr. T.K. Dayalu, again followed by in the case of Vemanna Reddy, that for the purpose of capital gains, the year of handing over possession in terms of section 53 capital A of TP Act, read with section 2, clause 47, subclause 5 of ITR, that would be the year of reckoning for taxing, for charging to tax the capital gains. Whereas if I go by that, because that decision came in 2011, whereas I have filed the return in 2008-9.
No, decision was declaratory of law or it made new law.
Declarative of law.
So well, that is applicable to you also.
Yes, yes, no, already Bombay High Court judgment was there in the case of Chaturabud Durgadas. Unfortunately, it was not followed. Return was filed for the assessment year 2008-9 income tax return, offering it to long-term capital gains, paying the tax. There some disallowances that has reached, I shall come to that later. Therefore, my original submission was, it was not urban land. It was falling into exemption. Now, after coming to know about this decision, in the wealth tax appeals, I filed the additional ground
Saying
before the tribunal, saying that on the valuation date of each of those years, what I was holding was only a right to get 15.3% of constructed area. Now, Milords would appreciate right to get specific performance is also a capital asset, as held by Honorable Bombay High Court in the case of Vijay Flexible Containers, 186 ITR, 693.
right to get
Specific performance is also a capital asset. I shall take Milord through the case law. I have included in the case law paperwork. And this has been laid down by Bombay High Court in.
But you paid advance tax not on that premise.
Not on that premise. I have offered it for capital gains, taking my original cost as the cost of acquisition with indexation and minus this 63 crore.
No, the question of right to specific performance would not arise because you had already rescinded the agreement.
Fair enough, Milord. Milord would appreciate I had no other option. I rescinded and now.
And sold property on the same day.
Correct.
To someone else by way of
Now,
settlement.
actually, strictly going by that, this happened in July 2007. Now, Milords are. What is the issue before Milords? Section 3 defines what is taxable wealth.
Let us see that.
Aggregate value. I'll take Milords through in a moment.
Okay.
Aggregate value of the properties, assets. Asset is also defined. Aggregate value of assets. Net wealth is the aggregate value of assets minus liabilities relatable to such assets. Right?
That is taxable.
On each valuation date.
On each value means what?
Valuation date is the last day of the previous year. Now for assessment year 2004-5, the valuation date was 31st March 2004.
On the eve of
The last of the years is 2007-8. Valuation date was 31st March 2007. And this rescinding took place in July 2007.
that is after the last date.
After the last valuation date involved in these appeals. On 31st March
So
2007.
that could not have been taken note of at all is your contention.
I was not, yes, I was not a clairvoyant. I could not have done that. Now, Milords would appreciate on each of the valuation date, what I was holding, because here it doesn't talk of ownership.
Before that settlement or rescinding followed by settlement,
Yes, Milord,
you had right to specific performance.
exactly.
That should be the basis for assessment by your contention.
Now, right to specific performance is a capital.
Also a piece of property for the purpose of capital gains tax.
Yes, Milord.
Therefore, that should have been the basis for taxation.
In fact, if I apply that principle, 2008-9, whatever was the fair market value of the right to specific performance will be my cost. That is when I rescinded, agreed to the rescinding of the contract, whatever I was likely to get would be the cost. And what I actually got was the sale consideration. The difference between these two, not my original cost of acquisition. That would be, it will be tax neutral. Milords would appreciate. Same time, I signed the settlement agreement rescinding. Next minute, I signed this.
But your earlier cost of acquisition need not be looked into.
No, that is what I have. mean, that will be the basis to arrive at this. Now, my consideration, my lord would appreciate, is to receive right to specific performance to get 15.3% of the constructed area. My earlier cost of acquisition was only relatable to the land. And I had no right in terms of the master development agreement to assign my right to anybody
Under MDA.
under MDA.
But he had that right.
He had the right to assign even my properties to somebody.
In that event, again, your right as against X would be available against Y in the event of assignment.
Now,
So-
after getting the constructed property, I could have told him, the developer, because I was otherwise contracted to sell everything through the developer. Even there, I didn't have a free hand to sell. Therefore, my hands were totally under. They were tight. I didn't have the elbow room to indulge in anything. Therefore, I thought the best of the proposition would be, now I have offered it to tax. Now the Wills tax assessments were reopened.
You paid wealth tax on what premise?
I have not paid any wealth tax.
Advance tax you had paid.
No, that is income tax,
Income tax, capital gains.
capital gains. Because throughout my cases, I am not accessible to wealth tax. Because even if one, again, my lords would appreciate, Wealth Tax Act does not go into ownership. It says urban assets belonging to. The term belonging to is a much wider concept.
Whether you are owner,
Dominion, who is having dominion over the property? Now, the entire dominion was in the hands of the developer.
whether belonging to is defined in the act.
Belonging to, there are
Plethora of
reams of,
judgments.
I mean, this court has decided, Supreme Court has decided, many courts have decided. That is how I have shown that I had absolutely no dominion over the property. Once I handed over possession,
Whether property is defined under the act.
assets are
Let
defined.
us see.
Yes,
Wealth tax act.
Wealth Tax Act. First, may I take my lords through section 3, the charging section.
Charge of wealth tax.
Charge of wealth tax. Actually, subsection 2 is relevant for us, but anyway, I shall take my lords through subsection 1 also. Subject to the other provisions, including provisions for the levy of additional wealth tax contained in this act, there shall be charged for every assessment year commencing on and from the first day of April 1957, but before the first day of April 1993, a tax hereinafter referred to as wealth tax in respect of the net wealth on the corresponding valuation date of every individual, HCF and company at the rate or rate specified in Schedule 1. Subsection 2. Subject to the other provisions contained in this act, there shall be charged for every assessment year commencing on and from the first day of April 1993, wealth tax in respect of the net wealth on the corresponding valuation date of every individual, HUF and company at the rate of 1% of the amount by which the net wealth exceeds 15 lakh rupees.
Subsection 1 is charging section.
Both two.
2
1 and
is
2.
a rate.
No, not only rate.
Huh?
I shall come to that, my lord. I shall take my lord through. There is a charging section, yes, my lord. Now, the terms, wealth tax in respect of net wealth is also defined. Now, net wealth is defined in section 2,
Net wealth.
2M, my lord. Section 2, clause M. Chargeable on the net wealth.
Net wealth means.
Net wealth means, it's an exhaustive definition. The amount by which the aggregate value computed in accordance with the provisions of this act of all the assets wherever located belonging to the assessee on the valuation date, including assets required to be included in his net wealth as on that date under this act, is in excess of the aggregate value of all the debts owed by the assessee on the valuation date, which have been incurred in relation to the said assets. Now, may I take my lord through?
Whether word asset is defined.
Yes, my lord. Section 2, clause EA. There are two actually, section 2, clause E, was the definition of assets which was in force till assessment year 92-93. First time I shall take my notes through section 2, clause E,
2E.
because the opening words are also very significant. 2E, assets includes. Will also on 2E.
EA, I have. E.
Both, first I shall take my notes through 2EA, because that is the relevant definition for all these appeals. Assets in relation to the assessment year commencing on the first day of April 1993 or any subsequent year means.
It's a means and includes definition.
Not includes, only means.
In below.
I am coming to that in a moment. Does not include says. That is, means this asset, for instance, any building or land appertaining thereto, whether used for residential or commercial purposes, for the purpose of maintaining a guest house or otherwise including a farmhouse, situated within 25 kilometers from the local limits of any municipality, whether known as municipality, etc., but does not include a house meant for residential purposes.
It excludes.
It excludes.
Means and excludes definition.
Yes, my lord. Then down clause 5 is urban land.
It's not included.
Subclause 5 is urban land.
Not included.
Urban land is included.
Eh?
Urban land is taxable because this exception is only subclause 1, 2, 3, 4, 5 of I. Subclause 1 has got again exclusions of 5.
1 second.
Subclause 2 is motor cars. Subclause 3, jewelry. These 5 exclusions are out of any building or land.
These 5 exceptions are
Only to
I.
Only for I. Yes, below. It's always a pleasure to. That is why it is printed with extra margin also.
Yes.
Then motor cars is II, jewelry is III, yachts, boats, aircraft
4.
4, then 5 is urban land.
So
Now,
urban land is also included.
now urban land is included. Then there is an explanation 1 below 6.
Explanation 1, that is jewelry. Above jewelry.
No, below that is 6 is cash in hand. After that, explanation 1, for the purposes of this clause is assets. Entire clause. Because these are all subclauses, my lord would appreciate.
Urban land.
Urban land, jewelry includes, etc. Urban land means land situated in any area which is comprised within the jurisdiction of a municipality, whether known as a municipality, municipal corporation, notified area committee, town area committee, or a cantonment board, and which has a population of not less than 10,000, according to the last preceding census of which the relevant figures have been published before the valuation date, or in any area within such distance not being more than 8 kilometers. This is, my lord would appreciate, at par with a definition of agricultural land, where agricultural income tax act, where agricultural land, agricultural income is also not taxable.
Correct.
And
Not taxable at the hands of parliament, but a state it can.
yes, no, as my lords are aware, section 82, I mean, list 1, entry 82 deals with only income tax.
Income tax. Not
So it is
agriculture.
indirectly tax, agricultural income tax, I mean, is levied by various states, different states. I mean, Karnataka also levies. But here, I mean, this is going at par with that. In the definition of,
Definition
now,
was that way.
my lord may kindly come to the exclusion to that. Beg me lord's pardon.
Urban land.
But does not include, after this 1 and 2, urban land means land situate 1 and 2.
Correct.
After that, but does not include land on which construction of a building is not permissible under any law for the time being in force, in the area in which such land is situated, or the land occupied by any building which has been constructed with the approval of the appropriate authority, or any unusual land, unused land held by the assessee for industrial purposes for a period of 2 years from the date of acquisition by him. Now the last 3 lines, or any land held by the assessee as stock in trade for a period of 10 years from the date of its acquisition by him.
For a period of 10 years.
10 years. Now, originally my claim was in terms of this exclusion till the stage of first appeal. It was held against me. Now, during the course of the first round of appeals before the tribunal, I filed an additional ground as a legal issue because all the facts are already on record. I said, I am not no urban land belongs to me. What belongs to me is only a right to receive 15.3% of
The land under MDA.
constructed area with corresponding undivided share in the land. That is a right to receive it back. And whenever I received, I was to surrender this total security deposit.
Till you receive.
Till you received, I was
Continue to be owner of that property only.
no, that is the question. Now, did the urban land belong to me? In
Or
terms
it belonged to
here, my lord,
builder.
yes, my submission is because he had the complete dominion over the property belonging to. The term is not ownership, belonging to. On that, there are umpteen number of decisions. I would be obliged to take my lord through all those decisions. How it does not belong to me.
But once you cancel, rescind the agreement,
Yes, my lord.
will it not relate back
It cannot be.
with effect
With-
from date
with
of
my respect-
rescinding? It affects.
No, my lord. The settlement agreement also I have. It is only with effect from that day.
That you rescind.
Yes.
Till then,
I lost my-
belonging to is with reference to the other party, developer.
Exactly. In
These-
fact, I have put it in my submission before the tribunal. If at all somebody was taxable, it was the developer who had complete dominion over the property. I had absolutely no say on whatever to be done on the land. At the most, I could go and see whether construction was taking place or not.
Did you tell the assessing authorities that it is he who is liable to pay, not me?
I did before the tribunal because this issue came only before the tribunal. I have raised this issue, my lord may kindly recall, not till the first appeal stage. It's a purely legal issue. Now, it is only in that connection, this honorable court in the first round,
Whether this appeal lies on substantial question of law or any question of law.
no, substantial question of law only. Here, there is one more section, my lord. Section 4, subsection 8. That talks of building. It doesn't talk of urban land.
Section
4, subsection 8. I mean, there also, section 53 capital A of TP Act is brought into play.
subsection 8,
53 capital A of TP Act,
subsection 8.
subsection 8, my lord. A person, my lords are on subsection 8.
Yes, a person
The
who
person who is allowed to take or retain possession of any building or part thereof in part performance of a contract of the nature referred to in section 53 capital A of the Transfer of Property Act, who acquires any rights excluding any rights by way of lease from month to month
This
or
may
for a
not be
period not
applicable.
exceeding, shall
This
be
is not
deemed to be the owner of the building or part thereof.
No, B is not applicable.
No, B is not applicable. Now, I mean, this is not strictly applicable to me because there was,
Deemed to be the owner of that building
yes,
or part
It is-
thereof,
yes, my lord,
and the value of such building
shall be
or-
included.
part shall be included in.
Net
but
worth
it's a
of such
of
person.
building.
It takes up, but that is why I am not taking any help from this. I am only drawing the Lord's kind attention to this, that 53 capital A is as a concept recognized under Wealth Tax Act
No.
also.
53A speaks of all immovable property
Exactly.
extensively defined under section 3 of the Transfer of Property Act, read with some provision in the General Clauses Act,
I'm grateful to my Lord.
number 1.
For a moment,
Whereas subsection 8 of section 4 it enacts 53A in a restrictive way, in the
I'm-
sense
absolutely I'm with my Lord.
it should be building.
I'm fully with my Lord on that. No, I am not drawing any support from 4.8. My Lord, may for a moment kindly have a look at section 2, clause 47, subclause 5 of Income Tax Act.
What is it?
Section 2, clause 47 defines what a transfer is. Section 2, clause 47.
Whether it is adopted in a Wealth Tax Act also,
Wherever the Wealth Tax Act does not provide,
we'll
then
go to that one.
yes, my Lord. My Lords are on section 2, clause 47. Transfer in relation to a capital asset includes
This is with effect from
right from 1.4. I mean, these subclasses have been added later. Subclass 5, my Lords may kindly see, was inserted by Finance Act 1987 with effect from 1.4.1988.
So this is applicable to you
Yes, my Lord.
as it is.
As it is applicable to me. In fact, I should have, that is how I filed the income tax return for assessment year 2008-9.
Transfer in relation to capital asset includes sale, exchange and
Sale, exchange,
relinquishment of the
relinquishment,
asset,
extinguishment of any rights therein, compulsory acquisition thereof under any law, or in a case where the asset is converted by the owner thereof into or is treated by him as stock in trade of a business carried on by him, such conversion or treatment, the maturity or redemption of a zero coupon bond that is inserted later, 4A, 5, any transaction, this is very critical, my lord,
involving
involving the allowing of the possession of any immovable property to be taken or retained in part performance of a contract of the nature referred to in section 53 capital A of the TP Act 1882. Now, for a moment, I may take
where you have parted with the possession of the property
in part performance of
in furtherance of agreement to sell.
in furtherance of the development.
No, it speaks
Here,
of
any transaction involving the allowing of the possession of any immovable property to be taken or retained in part performance of a contract of the nature. Now,
let us go to 53A. 53A does not say development, etc.
no, it does not say.
Does not say.
My lords, I am fully with here. My lords would appreciate in part performance of a contract.
Correct.
Of the nature of section 53A.
Correct.
Now, it is both development and transfer. Now, it is treated as a transfer in terms of section 247(5).
Whether you develop or not, if possession is parted,
yes, at that moment,
furtherance of a contract of sale or contract to sell, either way, 53A is attracted.
my lord may kindly bear with me. No, I'm fully on that concept. Various courts, including this honorable court, have held for the purpose of Income Tax Act in part performance of a contract of the nature of 53 capital A, when possession is handed over.
It need not be exact.
It need not be
Because
exact.
section uses the word in the nature
Of the nature of, exactly. That is the, parallelly, I have been carrying on research into Tirukkural, which is of 1st century BC. I mean, it's a pleasure appearing before Lord. I'm reminded of one of the verses. Unarvadu udayarmun sollal, valarvadan pathiyul neer surindatru. It is like watering plants on a fertile land to address an audience which is known for quickest grasp.
You are very gracious,
No, my lord.
regardless of
My lord,
not
I
dissertation.
have been
No, because we have some
no, that is,
exposure.
no, that is why, my lord may kindly recall, I was referring to Dr. T.K. Dayalu's case and Vemana Reddy's case, both of this high court, which have been become final, holding that where a contract, joint development contract, by virtue of that possession is handed over, then it is a transfer in terms of 247(5).
Correct.
First, Bombay High Court held it in the case of Chaturabud Dwarkadas.
Our High Court followed.
Our High Court followed, but it's the detailed order. Both, again, in the second case also, Vemana Reddy.
Is Kumar Urda? Kumar Urda?
The first round, I should just, it's a short decision, my lord.
Justice
Sabait, sir.
Lordship, what is relevant is not belonging to question of.
Both
going into
are there. Both are there. I mean, it cannot be cut short, cannot be cut tail, the submissions also. And all these have been gone through in the first round also. So,
In deciding whether there is a sale,
whether there is a transfer,
documents,
where there is a transfer.
transfer, correct. Only those two documents which the court has said ought to have been looked into is your case.
One is master development
A.
agreement. Then the development, the letter to confirm handing over possession within the financial year.
Only these two ought to have been considered.
The two more, my lord. Then the condition put for, along with this handing over possession, that I should get the conversion order also from agricultural to non-agricultural for all the three companies. That also I fulfilled. Then, most importantly, the transfer is complete in terms of the Income Tax Act. When I get an NOC under Chapter 20C of the Income Tax Act, my lords would kindly recall, there was Chapter 20C earlier for acquisition, where people were hiking up, to cut short on the money involved in real estate
So they
transactions.
had an option to buy the property.
Exactly. Therefore, every transaction involving more than 50 lakhs had to be cleared by the income tax department. And that transfer definition in that Chapter 20C is also at par with this. And I have obtained the NOC. That is also part of the master development agreement. Because along with possession, I was obligated to get the NOC and hand over. And in that NOC also, they have recognized 5th December 2000 as the date of transfer. One wing of the department says it is transfer for the purpose of Income Tax Act. And that is why, unwittingly, I have filed the
It is
return.
only for the purpose of that chapter,
No, not only for the chapter,
for act itself.
because,
That certificate which they give. is
no, that is for the purpose of that chapter.
Chapter alone.
As my lords are aware, not only for the purpose of this chapter, it is only for those two contracting parties. Supposing one of the parties, supposing I have rescinded even earlier,
Again, you have to take
I
one
go
more
to
certificate.
some other person, or I am thrown out by the developer, he goes to some other person. Either way, it is for the parties and for the amount of consideration, all these is the clearance put together. And
So ultimately, the pith and substance of your contention is
yes, my lord.
you were no longer the owner of this property. Therefore, the capital gains question, if at all were to be paid, they ought to have been paid by the developer, number one.
No,
Number two, no
Sorry for the interruption.
wealth tax could have been levied on your assets
Not-
because they were not
Not
your
capital gains, wealth tax.
wealth tax.
Yes.
Wealth tax ought to have been levied
Ought to have been levied on the
on him
developer.
and not on this.
Yes, ma'am. I have in fact put it in my written submission.
In other words, by virtue of this MDA, coupled with your confirmation letter, coupled with your converting the land to non-agricultural purpose, made the other party to the MDA as the person to whom the property belongs
Belong.
to.
Belong, exactly,
That is the question.
absolutely. Absolutely, that is.
If that is so, no levy of wealth tax could have been done
Exactly,
on you.
exactly. In fact, I have listed, just to assist my lords, I put it in the.
Now let us, 1 second. Now, that question ought to have been addressed by the parties only in a limited way because of the terminology of the remand order
Exactly.
is the relative contention.
In addition to that, one more angle to that. In fact, in the second round, I have given in writing, which is recognized in the impugned order, that I am not pressing the original grounds. At the beginning of my submissions before the tribunal, I have put it in writing, and they have also acknowledged it in the impugned order in para 5, that original grounds are not pressed. In spite of that, they again go into the original grounds and decide the issue against me. In spite of my showing them, these are all the parameters within which this appeal has to be decided. I put it in writing. I've taken them through these paragraphs 22 and 23. I don't know whether I can say that. My friend later on, when he bumped into one of those, so would you get another order to be decided by somebody else, not me? Like that.
Mr. Ramaswamy,
Yes, my lord.
let us have the foundational facts now.
Yes, my lord.
Your master development agreement is dated. When did you acquire these lands?
Between 96 and 98. In fact, I have
Yes.
given in a
Appellant.
short form
Appellant
this synopsis.
bought these lands during the period between
1996 and
1996 and
98.
1998.
My lord may kindly see this fact is also recorded here in the earlier, in the first round by their lordships. My lords may kindly take the running page, paragraph 3, my submissions, and then the paragraph 9 on page 138. And then paragraph 12 onwards,
138 of
the
which,
running page of the appeal memo, my lord.
the other appeal memo.
Same. Verde, that is 24.
WTA 4.
Yes. Now here, my lords may kindly come to page 139. After recording the submissions,
Well, tax is charged under section 3.
Yes.
Tax in respect of net.
there is a typo error. Instead of 2M, it is put as 2N.
2M we thought to have been.
It should be 2M. Now, para 13 gives all the facts.
It is not in dispute that the appellants own urban land
that-
and they are accessible for.
That is a sick statement, with utmost respect. That is a sick statement because the later findings nullify that. My lord may kindly come to para 14.
13 also.
13 also. 13 completely, 13, 14, 15. Then 18, clause 13 of the MDA requires the parties to submit relevant forms.
What
for-
is that CIDL?
That is classic
Other party.
infrastructure development limited.
Developer.
That is a
You are a
developer.
developer.
That is a developer, CIDL, 100% subsidiary of ITC. It is there on in para 3 million, classic infrastructure and development. That is on running page 133, fifth line from bottom. CIDL.
Why that each appellant was entitled for 15%, 15.3? How many appellants?
Three
appellants,
appellants, all the three.
the three cases.
So around 46% to 64%.
They will get the built-up area.
54.
Here it is only 15.3%. So the developer gets 84.7%.
Okay.
Not 60/40. I mean, these are not disputed. That is why I've summed up here. I've just,
Synopsis.
issues first, and then the facts not disputed in brief, and then the submissions. I try to be laconic, but one will have to, I will have to take my lords through. It is only to assist my lord, so that I can quickly take my lords through the relevant paragraphs and both in the case laws and
Let us take the synopsis now.
yes. The first, I have taken my lords through
Yes.
paragraphs 22 and 23.
So second page, the revised additional round.
Has not been specifically dealt with by the learned tribunal in the second round also. Indeed, in the first round of appeal, this was the mistake apparent pointed out in the MP number so and so, perversely dismissed by the tribunal by order dated 11/8/2016 and challenged before this honorable court. Having been convinced of the plea of perversity, this court directed by para 23D, running page 148 of the appeal memo, we direct that the appeal shall be heard by a different bench other than the members who have heard the miscellaneous petition. The appellants established their case that they had only a right to receive 15.3% of the constructed area with corresponding undivided share in the land, which is not a taxable asset in terms of definition of assets in section 2EA of the Wealth Tax Act, the Act for short, with effect from assessment year 1993-94 onwards. Besides establishing the transfer of urban land was completed as found in para 22 of the judgment of this court, dated 30/6/22. Definition of assets, we lords have seen. On page 3, in the impugned order of the learned tribunal, this fundamental issue has been completely overlooked by the tribunal, though specifically brought to its notice through synopsis and oral submissions. On the contrary, though the original grounds were not pressed, the tribunal proceeded to adjudicate on them, ignoring the additional ground raised on jurisdictional issue.
So the constructed area was not an asset at all.
Yes, my lord. mean, Millards, I'm taken Millards through
Cause of
2EA. Mean, right to get specific performance is not an asset. It's a capital asset. As held by various high courts, right to get specific performance itself is an asset. And I was holding only that right. Under Income Tax Act, so when I transfer a right to get specific performance, if it is long term,
It's a transfer.
it is taxable as long-term capital gains. 186 ITR 693 Bombay High Court, in the case of Vijay Flexible Containers, has held it following its own decisions in 122 ITR. And this was followed by Honorable Madras High Court also. In it, there is no difference of opinion on that. And this Honorable Court also has held. Because even now, there is one more.
You mean to say only your right to get specific performance alone could have been treated as an asset?
I have retained only that till the contract was rescinded. That is on each of the valuation dates. That was the only asset with me. Though.
That possession was already parted with him
Exactly.
and it belonged to him.
Exactly. Now, this was causing this kind of concept was causing, that is where it is transferred by virtue of 247(5) in a development agreement, where the consideration is only constructed portion. In many cases, the consideration is postponed. I don't receive.
It all depends upon
No,
terms of the MDA.
Absolutely, Milord.
If suppose if it says 15% developed area plus 1 crore rupees,
Yes.
then together it will be. It
That
all
also.
depends upon.
Now, particularly for individuals and HUFs, this was causing a lot of trouble because they didn't have the liquidity to pay the capital gains tax. Therefore, Parliament came with an amendment to Section 45, subsection 5 capital A. There they have excluded companies. All the appellants before me, lords, are companies. Now, the tribunal in the second round has applied 45(5)(A) to my case. My lords may kindly have a look at Section 45, subsection 5 capital A.
Not applicable to companies at all.
Not at all. It is only to individuals and HUFs who have put a lot of problems. Because without liquidity, now assessment was being made, demand was being raised. So they had no.
In your synopsis, where have you referred to that?
45(5)(A). Here. I have not specifically mentioned about that, but I shall take my lord through that. As I said, I tried to be very laconic as I submitted. My lords may kindly see 45(5)(A). This was also introduced, inserted only with effect from 1/4/2018.
1/4/2018.
Yes, my lord, as late as that.
But how that will be applicable to you?
They have said a transfer, so therefore I was holding the urban land. By virtue of this, they were borrowing this concept into my case.
They could not have at all.
Tribunal. I shall take my lord through the portion in the order, impugned order. My lord may kindly see.
Now we have other bench at 2:30.
Uh,
We'll fix some date convenient to you because
Tomorrow means subject to my lord's
tomorrow we have
convenience.
it.
Tomorrow morning, I mean, I can stay back.
Next Monday. Monday? Next
Uh,
Monday?
Next Monday.
Just one line submission, Lord. Merely because he has entered into joint development agreement,
Can
the
it be?
the interest in the land continues to be with owner.
But belonging to the
That,
concept
yes, Lord.
which has been interpreted by a coordinate bench of this court.
Yes, Lord. That
Yeah,
has not been
where-
interpreted, Lord.
Eh?
No, in the circumstances of this case, whether entering into a joint development right, can the assessee say that land does not belong to assessee?
If possession is given,
That is in respect of income tax. We are only concerned with wealth tax. Whether there is transfer in according to Income Tax Act, that is not relevant. Whether the land in question belong to assessee or not,
Now, whether transfer is defined separately under the Wealth Tax Act.
It is not defined, my lord.
Then
Your
we
lordship,
go back to the IT Act.
lordship belonging to, your lordship, in the Income Tax Act, when the joint development is entered into and part of the possession is given, then there is a transfer.
Correct.
In the Wealth Tax Act, Lord, the assessee continues to get the
No, there is a
benefit.
finding. There is a finding in the earlier order. Kindly come to,
Your lordship, in the
I-
earlier order, no substantial questions of law were answered. It is
No,
a
no.
demand.
kindly come to 146. Page 146, para 22. They had entered into the property. There is a finding.
Your lordship, paragraph number 22 in page number 146, my lord, your lordship is relying upon, that is an observation. The remand is open. It is to pass in accordance with law.
That's all right.
Yes, my lord.
But this is the finding.
In the light of the observations.
In the, your lordship, IT had to have. I have-
Combined, 1 second.
Yes,
Ju-
ma'am.
Just see that,
Yes,
just see
ma'am.
that. A combined reading of clause 10.1G,
Yes,
clause
ma'am.
13.1, 13.2 in clause A, Roman A
Hmm.
of the annexure A together with the no objection under chapter so in so IT Act and the letter written by Shri Dhingra prima facie demonstrates that the developers did have power to alienate their portion of property and they had entered into the property. This is the finding.
Your lordship, in the next order direction, your lordship, paragraph number six.
For reconsidering,
Yes, my lord.
it's a remand.
Yes, my lord.
But this finding,
That is only observation, my lord. In the paragraph C, your lordship, next page, my lord, matters are referred to the ITAT for fresh consideration in accordance with law.
In the light
By
of,
applying the applications, provisions of the act, my
no,
lord,
in the light of, see that.
in
how
the
it
light
is
of the
tested.
observation.
In the,
in accordance with law, in the light of the observations in,
it is just inappropriate for the ITA to have a look into the matter in the light of the contents of MDA,
Yes, my lord.
NOC issued under so and so, so and so.
and the letter.
If in the MDA,
Yes, my lord.
if it is shown that property is parted with
Yes, my lord.
in favor of Mr. Dhingra,
Yes, my lord.
then how that he becomes the owner of the property because it belongs to him.
Your
This
lordship,
is contention.
yes,
That you have to meet.
your lordship, one more submission, page number 35, my lord, ITAT order, when the matter goes back to the tribunal, my lord, paragraph number 5, page 35, my lord.
The whole case,
Yes, my lord.
we have to adjudge based upon the terms of the MDA
Yes,
and the letter, and he is converting the land to non-agricultural purpose. These three will be very, very, very essential. And to rebut that, you have to show some other material to us. Next date we will-
Whether all these materials will throw the light, whether belonging to assessee or not.
just
That's-
1 second, my lord.
Well-
This para 27 on running page 54.
Let us see. Now, we just, we will also again go
My
through
lord, instead of Monday, can it be Tuesday? my lord?
Tuesday,
Please,
Tuesday.
please.
Much obliged, my lord.
All.
Much obliged.
Thank you. You are from Hyderabad?
I'm settled in Hyderabad, otherwise, actually, if I may be permitted, just half a minute. I started as a lawyer in 1974. 76, I joined the IRS. My first posting was in Bangalore for 8 years, 78 to 86.
Oh.
After 28 years, I quit the service. I took VRS.
Oh,
Harshad Mehta raid was mine when I was in Bombay for 10 years.
oh,
I was co-opted as member of Janakiraman committee. I was happy. I had a illustrious career. First love always beckoned me, so I came back 20 years back.
oh,
July 2004, I came back to the profession.
very good.
I go to various tax benches only.
My lords, may I?
Humble submission, my lord.
Serial number 25, my lords.
25.
Yes, my lords.
Ah,
Interim order may kindly be extended.
ನೋಡಿ, ಎಲ್ಲೆಲ್ಲಿ entry ಮಾಡಿದೆ. Absolutely, it's absolute.
Your lordship, one humble submission, your lordship.
ಹಾ.
Morning ಕೊಡ್ಬೇಕಿತ್ತು ಮೆಮೋನ, but due to some inconvenience late ಆಯ್ತು. But your lordship, this matter was listed on 11th, your lordship, but not reached, simply adjourned. Kindly, senior counsel will argue the matter. Kindly date please to be fixed. Next week, any date.
4 weeks ಆಗಿದೆ.
Any
ಆ,
date.
ಜಯಕುಮಾರ್ ಪಾಟೀಲ್
Yes,
ಆ
your
ಕಾಮ ಬಗ್ಗೆ ಇತ್ತಲ್ಲ ಅದ
ವೀರಶೈವ ಲಿಂಗಾಯತ್.
ಅದೇನೋ 4 weeks ಏನೋ ಆಗಿದೆ ಅಂತಲ್ಲ. ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಇದೆ.
Simply adjourn ಆಗಿತ್ತು.
ಇಲ್ಲ, ಅದು 4 weeks ಅಂತ ಹೇಳಿ. ನೋಡಿ, ನೋಡ್ಕೊಳ್ಳಿ, ಅದು ಇಸ್ಕೊಳ್ಳಿ. 4 weeks ಆಗಲಿದ್ರೆ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹಾಕಿ. Please.
Serial number
Please.
25.
Please.
Serial number 25, Manoj, the government council, I think Arvind Chauhan was meeting,
Ah.
but nobody named.
It is served, my lord. No one has appeared, so.
25.
25.
Next week ಮಾಡೋಣ.
ಅಲ್ಲ.
Ah.
I may be directed to take notice. I'll let it be after 2
Three.
weeks.
So is requested to
25.
requested to accept notice.
Please.
We can't direct you. We
Please.
can only request you.
So the matter has been admitted and that's why we are.
It may be listed after 2 weeks. I'll get
List
it.
after.
A copy maybe.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Serial number 26 may seek for a date
26 ಯಾವ ಇಯರ್ದು?
of 23 month,
23.
arising out of land grabbing proceeding.
23 in the second week of March. Okay. All.
ಇಲ್ಲ, Arvind, panel council. Arvind V. Chauhan.
ಗುರುಗಳೇ.
ಇದೇನು ಬೇಡ. 4 weeks ಆಗಿದೆ ಸರ್ ಅದು.
ಅದ್ ನೋಡಿದೆ ನಾನು ನೆಟ್ ಅಲ್ಲಿ.
ಇಟ್ಟಲ್ಲಿ ಆಗಿಲ್ಲ, ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ. ನಾವು ಬರ್ದಿರೋದು 4 weeks.
ಮತ್ತೆ ಈಗ ಹೆಂಗ್ ಮಾಡ್ತಾನ?
4 weeks ಆದ್ಮೇಲೆ ಬರುತ್ತೆ.
4 weeks ಅಂದ್ರೆ
ಇಲ್ಲ, ಇದು ಬೇಕು, ಇಷ್ಟು ಬೇಕು.
ಅಲ್ಲ, ಆ 4 weeks ಆದ್ಮೇಲೆ ಒಂದು ಬರೀತೀರಿ ನನಗೊಂದು ಕನ್ಫರ್ಮೇಶನ್ ಇರ್ತೈತಿ.
Second week of March.
ರಾಘವೇಂದ್ರ ಜಿ
ಸರ್ ಹೇಳಿ.
ನಾವು ದೂರದಿಂದ ಬರೋರಲ್ಲ ಬುಕ್ಸ್
ಎವ್ರಿ ಟೈಮ್ ಲಾಸ್ಟ್ 2 occasions ಬಂದಿಲ್ಲ.
ಏನೋ ಅದು ಈಗ ಜನರಲಿ ಎಲ್ಲ 4 weeks ಆದಂಗ ಹೋಗಿದೆ. ಅದು ಒಂದ್ ಯಾವ್ದಾದ್ರು ಒಂದು ಹಾಕ್ಬಿಡಿ ಅದರ 4 weeks ನಂತರ ಒಂದ್ ಯಾವ್ದಾದ್ರು ಒಂದು ಹಾಕಿ
ಹಾಕ್ತೀನಿ ನಾವು. 4 weeks ಆದ್ಮೇಲೆ ಡೇಟ್ ಬ್ಯಾಂಚ್ ಕಳಿಸ್ತೀನಿ.
ಬರೀತೀರಾ ಡೇಟ್?
ನಾನು ಬರೀತೀನಿ.
ಓಕೆ, ಒಂದ್ ಡೇಟ್ ಹಾಕ್ರಿ ಯಾವ್ದಾದ್ರು.
ಹ್ಞೂ ಸರ್, 4 weeks ಆದ್ಮೇಲೆ ಡೇಟ್
ಅದೇ 4 weeks ಇದ್ದ ಆಮೇಲೆ ಡೇಟ್.
ಇವೇನ್ ಬೇಡ, ರೇಟಿಂಗ್ ಇದು ಬೇಡ ಅಷ್ಟೇ. ಏನ್ ಬೇಡ.
ಆಗ್ಬಿಡಿ ಹೋಗ್ಲಿ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್. ಎರಡು ನಿಮ್ಗೆ 2 ನಿಮಿಷ ಕೊಡಿಯೋದು.
ಇದೇನದು ಡಿಸ್ಮಿಸ್ಟಾ ಏನದು? ವಿತ್ಡ್ರಾನ?
ಇಲ್ಲ ರೀ, ಅದೇನ ಹಿಯರಿಂಗ್ ಆಯ್ತು. ಅಲೋನ್ ರಿಮೈಂಡೆಡ್.
ರಿಮಾಂಡ್
ಯಾವ್ದು ಫಸ್ಟ್ 423
ಯಾವ್ದು ರಿಸರ್ವ್ ಆಗಿಲ್ಲ. ಬನ್ನಿ ಸರ್, ಅಲ್ಲೇ ಹೋಗಿರುತ್ತೆ. ಬೈ ಎನಿ ಚಾನ್ಸ್ ಇವ್ರಿಗೆ ಆಯ್ತಾ ಅದು?
ಯಾರಿಗೆ? ಅಲ್ಲ ಅಲ್ಲ,
ನೀವೊಂದು ಕಾಣ್ತೀರ, ಇದಷ್ಟು ಕಾಲಾದ್ರೂ ಬಿಡಲ್ಲ. ನೀವೇ ಟೈಪ್
ಸಿನಾಪ್ಸಿಸ್ ಇತ್ತಲ್ಲ, ಎಲ್ಲ ಇದು
ಬೆಳೆ ತಂದ್ಕೊಟ್ರಲ್ಲ
ಇದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಏನಿಲ್ಲ. ಸಿನಾಪ್ಸಿಸ್ ಒಳಗೆ ಇಟ್ಟಿದ್ದು.
ರಘುನಂದ STRP ರಿಸರ್ವ್ ಮೇಡಮ್ ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ ಬಂದ್ಬಿಟ್ಟು. ಅದು
ಅರವಿಂದ್ ಬಿ ಚೌಹಾಣ್ ಇನ್ನೊಂದು ಇತ್ತು ನೋಡಿ, ಅರವಿಂದ್ ಬಿ ಚೌಹಾಣ್. ಅದೇ ಅದೇ ಇತ್ತು, ಟೇಬಲ್ ಮೇಲೆ ಇತ್ತು ನೋಡಿ. ಅದು
ಎರಡು ಕೊಟ್ಟನಲ್ಲ ಸರ್, ಯಾವ ಏನಿಲ್ಲ ಸರ್. ಕೊಟ್ಟೆ
ಎರಡು ದೊಡ್ಡ ದೊಡ್ಡದು, ಅದು ಬೇರೆ ಇದೆ. ಇದು ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಸೆಕೆಂಡ್ ಇದು ದೊಡ್ಡದು ಕೊಟ್ಟಿದ್ದು, ಇಲ್ಲಿ ಇದೊಳಗೆ ಹಾ ಯಾವ್ದು ಕಾಪಿ ಬಿಡಿ. ಅಷ್ಟೇ ಅಲ್ವಾ? 2 weeks ಅರವಿಂದ್ ವಿ ಚೌಹಾಣ್ ಅವ್ರ ಹೆಸರು, AJ ಬದಲು ಅವ್ರ ಹೆಸರು ಮುಗಿತಾನೆ.
ಇವರಿಗೆ ಫೈನಲ್ ಕೊಡ್ತೀವಿ ಅಂತ.
ಎಲ್ಲ ಅವ್ರಿಗೆ
ತುಂಬಾ ಕುತ್ಕೊಳ್ಳೋದು, ತುಂಬಾ ಬುದ್ಧಿ ಇಲ್ಲ.
ಎರಡು ಲಿಸ್ಟ್ ಇಟ್ಬಿಡಿ ಸಾಹೇಬ್ರು, ಸಾಹೇಬ್ರಿಗೆ ಇನ್ನೊಂದು ಇಟ್ಬಿಡಿ. ಬಂದಿದೆ ಇನ್ನೊಂದು ಸೆಕೆಂಡ್ ಇತ್ತು ಧಾರವಾಡ ಬಂದು
ಹೆಂಗ ಸೈನ್ ಅಲ್ಲೇ ಮಾಡಿಸ್ಬೇಕು. ಆ ಲಿಸ್ಟ್ ಬರ್ಬೇಕಲ್ಲ, MFA ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಧಾರವಾಡ ಬಂದಿದೆ, ಧಾರವಾಡ ಬಂದಿದೆ ಅಲ್ಲ ಇಲ್ಲೇ ಇದೆ.
ಅದೇ ಏನ್ ಕಾಣಿಸ್ತದೆ ಅದು ಅವಾಗ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು. ಧಾರವಾಡ ಮಾಡಿದ್ವಿ ಸರ್. ನಮಸ್ತೆ ಸರ್, ಪುಟ 7 ಇಂದ ಸರ್. ಸರ್ ಅದು ಪಾಲಿಶ್ ಮಾಡಿಲ್ಲ ಸರ್, ಅದು ಸಣ್ಣ ಸಣ್ಣಗಿದೆ ಸರ್. ಅದು 7 ಇಂದ ವೆರಿಫಿಕೇಶನ್ ಸರ್ ಶಿಕ್ಷೆ ಸರ್. ಹೌದು ಸರ್, ಪ್ರಿಂಟ್ಔಟ್ ಹಂಗೆ ಬಂದಿದ್ದೀನಿ ನೋಡಿ ಸರ್. ಹಲೋ ಮಹೇಶಣ್ಣ, ಮಹೇಶಣ್ಣ ನಾನು ಮಾತು ಶಿಕ್ಷೆ ಸರ್ ವೆರಿಫಿಕೇಶನ್ ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆ ಸೆಟ್ಟಿಂಗ್. ಟೂ ಮ್ಯಾಟರ್, ಇದು ಇದೆ ವಿಷಯ. ಒಂದು MFA ಇದೆ, MFA ಸಣ್ಣಗಿದೆ ಪ್ರಿಂಟ್. ಒಂದು 5 ಪೀಸ್ ಬೇಕು ಅದು. MFA ಧಾರವಾಡ ಬ್ರಿಡ್ಜ್ MFA ಅದು. ಹೌದಾ, ಅದು 138 ಇದೆ. ಅದು ಚೆನ್ನಾಗಿದೆ, ಓಕೆ. ಅದು 45 pages ಚೆನ್ನಾಗಿದೆ. ಇದು 2 pages ಚೆನ್ನಾಗಿದೆ. ಓಕೆ. ಅವಾಗ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ ಚೇತನ್ ಸರ್. ಚೇತನ್ ಸರ್ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಬೇಕು ನೀವು. ಚೇತನ್ ಸರ್ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಬೇಕು ತಾನೆ ನೀವು. ಬಂದಿದ್ದೀರ ಚೆಕ್ ಮಾಡ್ಬೇಕು ತಾನೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದು ಏನ್ ನೀವೇ ನೋಡ್ಬೇಕು ತಾನೆ. ನೋಡ್ಕೊಂಡು ನೀವೇನ್ ನೋಡ್ತೀನಿ ನೋಡಿದ್ರೆ ಸಣ್ಣ ಬೈತಾವ ನೋಡಿ ಸರ್. ಒಂದೇ ಬೆಟರ್ ಅಲ್ಲ, ಇದೆ 2 meters. ಇದು ಒಂದು, ಇದು ಒಂದು, ಇದು ಕನೆಕ್ಟೆಡ್. ಇದು ವರ್ಡಿಂಗ್ಸ್, ಈ ವರ್ಡಿಂಗ್ಸ್ಗೆ ಇದಾಗಲ್ಲ. ಅದು ಇದ್ರ ಕಾಪಿ ತೆಗೆದ್ಬಿಟ್ಟಾರೆ, ಫೈನಲ್ ಕಾಪಿ 4 pages ಆಗುತ್ತೆ. ಇದು ಆಗ್ಬೇಡಂಗಿದಂತೆ ಯಾವ ಆಗ್ತದೆ ಅದು ಒಂದು ಬಂದಿದೆ ನ್ಯೂಸ್. ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ ಹಂಗೆ ಅರ್ಜೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಸೋದು ನೋಡಿ ನ್ಯೂಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಅದು ಇದೇ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದ್ದೀನಿ ಇದು ಇದು ಎಲ್ಲ ಬಿಡ್ತೀನಿ. ಅಲ್ಲ ಚೇಂಬರ್ಲಿ ಬಂದ ಹಂಗೆ ಸೈನ್ ಆಗ್ತದೆ. ಚೇಂಬರ್ ಮಾಡಿ ಸರ್, ನೀವು ಯಾಕೆ ಸುಮ್ಮನೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಾ? ಮಾಡ್ಬಿಡಿ ಪ್ಲೀಸ್, ಹೋಗಿ ಸರ್. ನೀವು ನಿಮಗೆ ಖಾಲಿ ಮಾಡ್ತೀವಿ. ನೀವು ಖಾಲಿ ಮಾಡಿ ಹೋಗ್ತಾ ಇರ್ಬೇಕು ನೀವು. ಆಯ್ತು, ಹಿಂಗೆ ಮಾಡಿಬಿಟ್ಟು ಇದು ಬರ್ದಿದ್ದೀನಿ.
ಒಂದ್ ಕಡೆ ಆಗ್ಬಿಡುತ್ತೆ. ಇದು ಒಳಗೊಂದು ಇದೆ. 8 ಮೀಟರ್ 4 ಮೀಟರ್ ಇದೆ. ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಂತ ಫಸ್ಟ್ ಸೆಟ್ ಅಂತ ತಕ್ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ಸೆಕೆಂಡ್ ಸೆಟ್ ಇದೆ ಅಂತ ಬುಕ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಇದು ಫಸ್ಟ್ ಸೈನ್ ಮಾಡಿಸ್ಬೇಕಂತ. ಫೋನ್ ಯಾಕೆ ಫೋನ್ಗೆ ರೆಸ್ಪಾನ್ಸ್ ಮಾಡೋದು ಈಗ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಸುಮ್ಮನೆ
ಕೆಲಸ ಹಲೋ ಈಗ ಹೆಂಗೆ ಅಪ್ಲೋಡ್ ಅರ್ಜೆಂಟ್ ಅದು ಲಾಗಿನ್ ಆಯ್ತು. ಬೆಂಚ್ ಐ ಡಿ ಎಲ್ಲ ಆಯ್ತು. ಬೆಂಚ್ ಐ ಡಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೇಸ್ ನಂಬರ್ 23 ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಅರ್ಜೆಂಟ್ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಕ್ಲಿಕ್ ಮಾಡ್ತಾರೆ. ಮಾಡಿದೆ. ಆಮೇಲೆ ಸಬ್ಮಿಟಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಅಂತ ತೋರಿಸ್ತದೆ. ಅದು ಹೋಗ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕ್ಲಿಕ್ ಮಾಡಿದೆ. ಆಮೇಲೆ ಬಟನ್ ಇಲ್ವಲ್ಲ, ಬಟನ್ ಇಲ್ಲ. ಕೇಳ್ತಾರೆ ನಮಗೂ ಗೊತ್ತಾಗ್ತದೆ. ನೀವು ವಾಪಸ್ ಬರ್ತೀರಾ ಬರಲ್ಲ? ಓಪನ್ ಮಾಡಿದೆ. ನೆಕ್ಸ್ಟ್ ಏನು ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು? ಮತ್ತೆ ಲಾಗಿನ್ ಮಾಡಬೇಕಾ? ಲಾಗಿನ್ ಮಾಡಬೇಕು. ಇವಾಗ ಏನು ಕೊಡ್ಬೇಕಾ? ಕೋರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಾಡಬೇಕು ಆಗಲ್ಲ. ಬಂದ್ ಮಾಡ್ರಿ. ಎಂಟ್ರಿ ಮಾಡಿ
ಜಸ್ಟ್ ಈಗ ಸರ್ ಸುಮ್ಮನೆ ಮೇಡಮ್ ಇದಾರೆ.
ಇಲ್ಲ
ಮೇಡಮ್ ಸುಮ್ಮನೆ ಮೇಡಮ್ ಈಗ ಹೋಗಿದ್ದಾರೆ. ಸರ್ ಒನ್ ಏನಾಗಿದೆ ಸರ್? ಅದು ಟೈಪಿಂಗ್ ಚೆಕ್ ಮಾಡಿ ಸರ್. ಒಂದು ಏನಾಗಿದೆ? ನೋಟಿಸ್ ಆಗಿದೆ ಮೇಡಮ್. ಒಂದು ಮಿನಿಟ್ ಮೇಡಮ್,
ಬೇರೆ ಬೇರೆ
ನೀವು ಮೇಡಮ್, ನೀವು ಯಾರು ಮೇಡಮ್?
ಗೊತ್ತಿಲ್ಲಪ್ಪ.
ಅಯ್ಯೋ ಒಂದು ಮಿನಿಟ್ ಮೇಡಮ್ 1 ವೀಕ್ ಆಗಿದೆ ಮೇಡಮ್. ಅದು ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಂತ ಇದೆ ಮೇಡಮ್. 712 ಮೇಡಮ್. 712 ಕಲೆಕ್ಟೆಡ್ ಬೈ ಸರ್. ಅಯ್ಯೋ ಮೇಡಮ್ ಅದು ಮಧ್ಯಾಹ್ನ ಹೇಳಿದ್ರು ಬಂದಿತ್ತು. ಮಧ್ಯಾಹ್ನ ಪ್ರದೀಶ್ ಸಾಹೇಬ್ ಜೊತೆ. ಡೀಲ್ ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ 138 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. 138 148 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಎಷ್ಟು ಗೊತ್ತಾ ಮೇಡಮ್? 113 ಮ್ಯಾಟರ್ಸ್ ಆಗಿದೆ. 113 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಕನೆಕ್ಟೆಡ್. ಓಕೆ ಓಕೆ ಓಕೆ.
Final hearing ಬರುತ್ತಲ್ಲ sir.
So 2 weeks. Second March ಅಂತ ಹೋಗಿದೆ.
WTA ಅಲ್ವಾ ಅದು? WTA
26.
WTA ಒಂದಿದೆ ನೋಡಿ, ವೆಲ್ತ್ ಟ್ಯಾಕ್ಸ್.
TA
ಹಾ
25th ಹೋಗಿದೆ ಸರ್.
25th ಹೋಗಿ.
Thank you sir.
ಸೊ ನಾವು 24.
ಅದೇ ಸನ್ಮತಿಯಲ್ಲಿದೆಯಲ್ಲ ಬಲರಾಮ್.
ಓಕೆ ಸರ್.
ಡ್ಯೂಟಿ ಹೋದಪ್ಪ ನಿಮ್ ಕೋಟ ನಿಮ್ ಕೋಟ ಅಂತ ನಮ್ ಕೋಟ ಡ್ಯೂಟಿನೇ ಮಾಡಲ್ಲ ಎಸಿನೇ ಇಲ್ಲ ನಮ್ ಕೋಟ ಬಂದ್ ಮಾಡುವ ಆಮೇಲೆ ಜಾಸ್ತಿ ನಾನು ಮಾಡ್ತೀನಿ ಅಲ್ವಪ್ಪ ಪರವಾಗಿಲ್ಲ ಕಣ ಬೇಕಂತರಿ ಪಾಲಕರಿ ಹಾ ಪಾಲಕರಿ ಇದೆಯಾ ಪಾಲಕರಿ ಅಂದ್ರೆ ಬೇರೆ ಕ್ಲೀನ್ ಪಾಲಕ್ ಬಂದಿರ ಪಾಲಕ್ ಸಾಕು ಸರ್ ನಾನು ಆಫೀಸ್ನಲ್ಲಿ ಇದ್ದೇನೆ ಹೌದಾ ಆಯ್ತು ವಿಧಾನಸೌಧಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದೀರನು ಹಾ ಹೌದು ಆಯ್ತು ಸಾಯಂಕಾಲ ಮಾಡ್ತೀನಿ ಕಾಲ್ಗಟ್ಟೆ ನಾನು ಮನೆ ಬಿಡೋದು 9:25 9.
ಮೂವತ್ತೈದ 25 ಅಂದ್ರೆ ಅಯ್ಯೋ ಮೇಡಮ್ ಏನಿಲ್ವಾ ಹೌದಾ 22 ಅಂತ ಹೇಳಿದ್ರು ಮೇಡಮ್ 22 ಲಿಖಿತ ಮೂವಿ ಹಾಕಿಂದ ಹೇಳಿದ್ರು ನಾನು ಕೊಡಿ ಎಂದು ಹೇಳಿದ್ರು ಹೌದಾ 35 ಆಗಿದೆ ಅಂತ ಆಮೇಲೆ ಲಿಖಿತ ಅಷ್ಟು ಇರಬೇಕು ಯಾವ್ದು ಇರಬೇಕು 23 ಇರಲ್ವಾ
ಆರಾಧ್ಯರ ಕಡೆ ಅವರು ಆರಾಧ್ಯರು ಬಂದಿದ್ರು ನಮ್ಮಲ್ಲಿ ಅವರು.
ಸೂರ್ ಅದು ಹೇಳ್ಬಿಡಿ, ನಾನು ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಪಾಸ್ ಓವರ್ ಆಗಿ ಮಾಡ್ತೀನಿ. ಹೋದೆ ಮಾಡ್ತೀರಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ನಾನು ಮುಗಿಸ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ತೀನಿ. ಬರ್ಬಿಡಿ, ತಗೊಳ್ಳಿ. ನಾನು ಇದು ಬಂಡ್ಲೆ ಎತ್ತಕ್ಕಾಗಲ್ಲ. ಏನು 2 weeks ಹೇಳಿ ಚೇತ ಮಾಡಿದ್ದಾರೆ. ಇದು ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್. ಇನ್ನೊಂದು 25/10. 3 25/10 ಎರಡೂ ಸೇರಿ 25/10. 25/2. ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಹೇಳಿ ಪಾಸ್ ಓವರ್. ಅದು ಬೆಳಗ್ಗೆ ಆಗಬೇಕಲ್ರಿ ಜೊತೆಗೆ 90 and 20 ಗೆ ಪೋಸ್ಟ್ along with serial next week. ಓಕೆ ಸರ್, ಅಲೋ ಮಾಡ್ಬಿಡ್ತೀನಿ. 2018 ಮ್ಯಾಟರ್ ಟ್ಯಾಕ್ಸ್ 2 weeks ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಆಗೋದಿತ್ತು. ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸಬಲ್ ಆಗೋಗಿದೆ ಸರ್. ಇಲ್ಲರ್ ಮ್ಯಾಟರ್. ಸೊ ನಾಳೆ ಇಲ್ಲ ನಾಳೆ ಯಾವತ್ತು? ನಾಳೆ ಇಲ್ಲ, ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ಬೋದು ಪೆಂಡಿಂಗ್. ಮೆಮೋ ಕೊಡ್ಬೇಕು. ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಕೊಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತಾ? ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತಾ?
ಇದು ಮೊನ್ನೆ 14th 692 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತು. ITA 692 ಮತ್ತೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ತಂದ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹೇಳಿ.
ಇದು ಅಪ್ಲೋಡ್ ಆಗಿರೋದು ಆರ್ಡರ್ ರಾಂಗ್ ಆರ್ಡರ್.
ಹಲೋ, ಶೀಟ್ ಬರ್ಬಿಡಿ, ಆಮೇಲೆ ಚೆಕ್ ವೆರಿಫೈ ಮಾಡಿಸ್ತೀನಿ. ಯಾವ ಡೇಟ್ ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ಏನಾಗಬೇಕಾಯ್ತು ಇಲ್ಲ.
ಅದು ಯಾವ್ದೋ ಬೇರೆದ್ರ ಆರ್ಡರ್
ಏನ್ ಮಾಡ್ತಾರಪ್ಪ ಅವ್ರುಗಳು.
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇಡಮ್ ಹೇಳಿ.
ಹಾ ಸರ್, ಅದು ಧಾರವಾಡ ಬೆಂಚ್ ಕರೀತೀರಲ್ಲ?
ಇಲ್ಲ ಮೇಡಮ್, ಅದು ಆಮೇಲೆ ಕಡೆ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ತಗೊಂತಿದ್ದು.
ಫಸ್ಟ್ ಯಾವ್ದು ತಗೋತೀರಿ ಸರ್?
ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ತಗೊಂತೇವೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಧಾರವಾಡ ಬೆಂಚ್ ಇಲ್ಲೇ ಬರ್ತಾರಲ್ಲ ಇಬ್ರು, ಇಬ್ರು ಇಲ್ಲೇ ಬರ್ತಾರಲ್ಲ ಸರ್. ನಮ್ದೊಂದು ಯಾಕೋ ಲಿಸ್ಟೇ ಆಗ್ತಿಲ್ಲ ಬಾಸ್.
ಯಾವ್ದೋ ಎಮರ್ಜೆನ್ಸಿ ಟೀಚರ್ಸ್ ಅಂತ ತಗೊಂಡಿರೋದು, ಅದು ಲಿಸ್ಟ್ ಅದು ಹೆಂಗ್ ಮಾಡಿದ್ರೆ ಲಿಸ್ಟ್.
ಈ ಕಾಂಬಿನೇಷನ್ ಎರಡೇ ಮ್ಯಾಟರ್ ಇರೋದು, ಒಂದ್ ತಗೊಂಡಿದ್ದಾರೆ, ಇನ್ನೊಂದು ತಗೊಂಡಿದ್ದಾರೆ.
ಯಾವ್ದು?
ಇನ್ನೊಂದು ಅವ್ರದ್ದು ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಮ್ಯಾಟರ್ ಇದು, ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಅದಕ್ಕೆ 1000103 ಆಫ್
ಯಾವ್ದು ಹಾಕ್ಬಿಡ, ಇದು ಒಂದೇ ಹಾಕ್ಸೋ ಒಂದಿದ್ರು. ಇದು ಇದೇ ಮ್ಯಾಟ್ರ್ ಇದೆ, 21 ಬಂಡ್ಲ್ ಇದೆ, ಅದ್ರ ಜೊತೆಗೆ ಅದು 2 ಸೇರಿಸಿಲ್ಲ. ಹೇಳ್ತೀನಿ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಕರೆದ್ಬಿಟ್ಟು ಅರ್ಜೆನ್ಸಿ ಇದೆ ತಗೊಳ್ಬೇಕು. ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಏನಿಲ್ಲ, ಸುಮ್ಮನೆ ಮಾಡಿಸ್ತೀನಿ.
ಅರ್ಜೆನ್ಸಿನೇ ಇಲ್ಲ ನಮ್ದು, ಇನ್ನ ಸಿಕ್ಕಾಬಡೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಇದನ್ನ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಆಕ್ಚುಲಿ.
Only one matter, 2:30.
ಹೇಳಿದ್ರೆ ಏನ್ ಸಂಬಂಧ? ಎಲ್ಲಾರು ಫೋಟೋ ಇದೇ ತರ ಹಾಕ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಯೂನಿಫಾರ್ಮ್. ಲೇಡೀಸ್ ಹುಡುಗರ ತರ ಮೇಲ್ ಪಾಕೆಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬೇರೆ ಡೀಟೇಲ್ಸ್
88,692 along with so on so 14(2) ಗೆ
ಇದು ಬೇಕಾದ್ರೆ ಇಟ್ಕೊಂಡ್ಬಿಡಿ.
ನಮ್ಮ ಹತ್ರ ಇದೆ ಅದು. ಎಸ್, ಆಮೇಲೆ ಚೆಕ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಮಾಡಿಸ್ತೀವಿ.
ನಾಳೆ ಕೇಳಿದ ನಾಳೆ ಬಂದು ವಿಚಾರಿಸಿ.
ಇಲ್ಲ, ನೀವು ಆಮೇಲೆ 5 o'clock ಬಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಏನ್ ಮಾಡೋದು? ಕುತ್ಕೊಂಡ್ರು ಅಂತ ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಹಾಕಿದ್ದಾರೆ, ಬೇಡ ಅಂದ್ರು. ಕೊನೆಗೆ ಹಾಕ್ಸಿರೋದಿಲ್ಲ, ಆದ್ಮೇಲೆ ಮತ್ತೆ ರೆಡಿ ಹಾಕ್ತಾರೆ. ಅದಕ್ಕೆ ಕರೆಕ್ಟ್ ಹೋಗಲ್ಲ, ಫಸ್ಟ್ ಇದು ತೆಗ್ದ್ಬಿಡೋಣ. ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಅದು ನಮ್ದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಧಾರವಾಡ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅದೇ ಲಿಸ್ಟ್ ಕರೀತೀರಾ ಅಥವಾ ಇನ್ನೊಂದು ಇದೆಯಾ? ನಮ್ಮ ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್ ಅದು ಲೇಟ್ ಆಗುತ್ತೆ
ಸರ್. ಫಸ್ಟ್ ಯಾವುದು?
ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್
ಡಿವಿಷನ್ ಏರೂರು ಸರ್.
ಅದೇ ಎರಡು ಅವ್ರದ್ದೇ, ಎರಡು ಅಷ್ಟೇ. ನಮ್ಮ ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್ ಟೀಚರ್ಸ್ಗೆ ಮೇಲೆ ಇದೆ.
ಧಾರವಾಡದ ಒಂದಿದೆ.
ಧಾರವಾಡ 2 ಇದೆ.
ಧಾರವಾಡ 2 ಇದೆಯಾ? ಇಲ್ಲ, ಒಂದೇ ಇದೆ.
2 ಮ್ಯಾಟ್ರ್.
ಓ, 2 ಮ್ಯಾಟ್ರ್.
ಇದು ಎಷ್ಟನೇ ಲಿಸ್ಟ್ ಸರ್? ಇದು ಲಿಸ್ಟ್ ಯಾವ್ದು? ನಂಬರ್ ಇಲ್ಲ, ಧಾರವಾಡ ಬಂದು
ಫಸ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡೋದಲ್ಲ.
ಅದನ್ನೇ ಮೆನ್ಷನ್ ಮಾಡಿ. ಇಲ್ಲ, ಈಗ ಅದನ್ನೇ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ. ಅದೇ ಸರ್
ಬಂತು ಆಮೇಲಿಂದ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾಯ್ತು ಸುದರ್ಶನ್ ಇವತ್ತು ಮಾಡ್ಸೋಣ ಬನ್ನಿ ಸರ್. ಇದಿರ್ಬೇಕಾದ್ರೆ ಇದೊಂದು ಬಿಟ್ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದು ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀನಿ ನಾನು.
ಇಲ್ಲ ಸರ್ ಇನ್ನೊಂದು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು.
ನಮ್ಗೆ ಇದೇ ತಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ, ಈ ಫೈಲೇ ತಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ. ಇದೇ ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ತಾರೆ ಮಾಡಿ. ನೀವು ಡಿಸ್ಪೋಸ್ ಮ್ಯಾಟರ್ ಅಪೀರ್ ಆಗ್ತೀರಾ?
ಡಿಸ್ಪೋಸ್ ಆಗಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು 2 ಸತಿ.
ಹಾ.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಎಷ್ಟು ಸತಿ
ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿಲ್ವಲ್ಲ?
ಹಾ?
ಬೆಂಚೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿಲ್ವಲ್ಲ?
ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿಲ್ಲ.
ರವಿ ನಿಮ್ಗೆ ಫೋನ್ ಬಂದಿದೆ ನೋಡಿ ರವಿ, ನೀವು ಎಲ್ಲೋದು ನಿಮ್ಗೆ ಫೋನ್ ಬರ್ತದ ರವಿಗೆ.
Court officer. Court officer.
Has been decided.
Court officer.
Number?
Court officer. Court officer.
ಇದನ್ನ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಬೇಕು.
ಸರ್ ಸುದರ್ಶನ್ ಸರ್, ಯಾರ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು ನಿಮ್ದು? ಯಾರ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು ನಿಮ್ಮ ಹೆಸರು? 1.24 for K-Waiter in place of.
Court officer.
Madam, ಹೇಳಿ.
AG Mala Bhute from Dharwad bench.
Okay, madam.
Okay.
Section 87.
Can I just give a call?
ಮಾಡ್ತಾರೆ ಅವ್ರು ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ. ಬಸವರಾಜ ಎಲ್ಲರೂ ಇಷ್ಟಪಡ್ತಾರೆ ನೀವೇ ಹೇಳ್ತಾರೆ. ಇದರಲ್ಲಿ ಮುಂದೆ ಬರ್ಕೊಳ್ಳಿ 1.24 ನಲ್ಲಿ
ಹೇಳಿ ಸರ್.
ಡೈರೆಕ್ಟ್ ಶೋ ನೇಮ್ ಆಫ್ ಎಸ್ ಸುದರ್ಶನ್ ಇನ್ ಪ್ಲೇಸ್ ಆಫ್ MS ಪಾರ್ಥಸಾರಥಿ. 1.24 MS ಪಾರ್ಥಸಾರಥಿ. ಇಲ್ಲಿ ನನಗೆ ಇದು ತಲೆ ಕೊಡ್ತಾ
ಅಷ್ಟೇನಾ ಸರ್?
ಮೇಡಮ್
ಬೇರೆ ಕೊಟ್ಬಿಡಿ ಓದ್ತಾಯ್ತು ನಾನು.
ಇನ್ ರಿಟ್ ಅಪೀಲ್ ಫಸ್ಟ್ ಇನ್ ರಿಟ್ ಅಪೀಲ್ ಓದ್ಬೇಕಾ ಇಲ್ಲ ಅಡ್ವೊಕೇಟ್ ನೇಮ್ ಆದ್ಮೇಲೆ ಇನ್ ರಿಟ್ ಅಪೀಲ್ ಓದ್ಬೇಕಾ ಮ್ಯಾಮ್? 1.24 ನಿಮಗೆ ನೀವು ಕೊಡಿ. ನಿಮ್ಮ ಬಂದಲ್ಲಿ ಕಾಸ್ಟ್ ಎಷ್ಟು? ನಿಮ್ಮ ಮೇನ್ ನೀವೇ ಮಾಸ್ ಇದು ಕಾಸ್ಟ್ ಎಷ್ಟು ನಿಮಗೆ? ಕಾಸ್ಟ್ ಎಷ್ಟು ಇಂಟು ಮೇಡಮ್
ಇದೆಯಾ
ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟರೆ ಅವ್ರಿಗೆ?
ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕು ಮೇಡಮ್.
ಅವ್ರಿಗೆ
ಮೇಡಮ್ ಲಿಖಿತ
ಕನ್ನಡ
ಯಾಕೆ
ಹಿಂದಿ ಬರ್ತದೆ. ಆಮೇಲೆ ಹೈಕೋರ್ಟ್
ಅದು ಒಂದೇ ಇದೆ ಮೇಡಮ್. ಜಸ್ಟ್ ಮಾಡಿ ಬರೋದಿಲ್ಲ ಅನ್ನಿಸ್ತಾನೆ. ಬರೋದಿಲ್ಲ ಅನ್ನೋದು
ಪವರ್ ತಡ್ಕೊಂಡು
ನೀವೇ ಕೊಟ್ಟರು.
My lord's permission. One matter, please, my lords. It was pertaining to Dharwad bench, please, my lords, in the same combination. This was disposed of, please, my lords, by my lords.
The
And
Canara Bank
election-
matter,
Please, my lords.
bank matter.
Please, RBI matter.
Yes, when do you want it, Mr. Cost?
Any date convenient, please, my lords, next week. Memo for posting. Agila,
When the combination is sitting on that day.
please. Obliged.
Lots, with the kind permission. Let's, Dharwad bench matter, serial number 2. Let's, all the while, senior counsel, MB Nargun sir was appearing in this matter, KNL matter where compliance reports were filed. Last date, lots, it was fixed on 9/6/23. Sitting was cancelled, therefore, it was not listed. Today, due to some, senior counsel is not in station.
My lord, I am for the respondents 2 and 3 in this matter, your lordship.
Yes. Okay.
Due to some personal inconvenience, he is not in session.
He is appearing for?
For the appellant, KNN.
My lord, I am appearing for respondents 2 and 3, your lordship.
All right. Work good. At the request of learned counsel appearing for the appellant, release this matter on
First week of
March
please.
7th. Some other next. 14th March.
Please.
Great. 14th March. 14th March, madam.
Please, my lord, one submission, your lordship. In this case, I have filed an application for direction for adjudication the rights of the first appellant with the in terms of the order passed by this honorable court on 6/9/2019, my lord. And the respondents 2 and 3 are the land losers, my lord. They have lost their land in the year 2008, your lordship. And the award is passed in the year 2010, my lord. And in connected matters, the this honorable court has awarded rupees 8 lakh per acre, my lord.
We will consider that matter. We will hear you and pass orders. We'll consider all that.
Please, your lordship.
14th.
Please, your lordship.
Yes, same stage. Further.
Obliged.
Obliged.
Seal number 1, matters pertaining to Dharwad bench, Lakshman T. Mantagani.
I am for the appellant, my lord. But this matter has been, my lord, partly allowed, wherein, my lord, this honorable court, para 6, my lord, last paragraph, wherein, my lord, in respect of, my lord, all other, my lord, the benefits and other things, my lord, placed intact. Now, my lord, the last portion of the order, my lord, cost made easy. Therefore, my trial court is saying that, my lord, there is no order, specific order for cost is concerned. They are not, my lord, giving.
Counsel for the appellant notifies mistake of the court in denying courts to his client. He is successful in the appeal. First, it has been settled from the days of Privy Council that ordinarily a successful litigant should get the costs first. Next one. In the above circumstances, the last part of the judgment which says inversely, costs made easy is deleted, and in its place it is made clear. ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಬರಿಬೇಕು. ಅಲ್ಲಿ in the above circumstances that apart at paragraph 3 in at paragraph 3B, what has been observed is also violated by denying costs. First, in the above circumstances, the request of the appellant to rectify the judgment to award costs is accepted. First, as a consequence, the last line comprising of 3 words in the judgment at page 7, that is, inverse that, costs made easy, is struck off, and appeal is allowed with costs. Rest of the things I'll cover. Order on IA number 1. IA allowed.
Much obliged.
You are right.
Much obliged.
Peace house. The registry to issue free copy of the order if applied for.
For orders, list number 1, Government Advocate, Janardana ji.
Not fully ready with the matter. Lordship can grant me 4 weeks time. Finally.
Start madli.
Our appeal, the Lordship grants finally 4 weeks time.
ಅಲ್ಲ ಕೊಡ್ತೇವೆ ನಾವು ನಿಮ್ಗೆ. But ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಿ in case ಅಂತ at least the frame of the case will be known to you.
Yes.
It becomes easy for you to resist it that way.
Yes.
Say state appeal.
State appeal.
State appeal.
Already
Because of the
State appeal, ನಿಮ್ಮ appeal. They have to argue. There is change of
Supreme Court. Supreme Court had disposed of the matter on Friday,
saying
saying that requesting the
court to decide this matter.
expeditious matter. It may be permitted to pass on the order.
Learned counsel appearing for so and so points out that Apex have asked us to dispose of these appeals expeditiously. First, the same is noted. Yes. Expeditiously. Yes.
And
Let them start their
ಅಲ್ಲ ಅವರು ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಚೇಂಜ್ ಆಫ್ ಪ್ಯಾನಲ್ ಆಗಿದೆ ಆಫ್ಟರ್
maybe
There's already an order. Say that the page section not as being the scale which was being paid.
That is not the regular election, which is sort of been used thereafter. But there are several matters, which are pending on the court. Being acted, not in spite of there being direction or clarification. At the hands of the court saying that there is no say of order of the single judge. Because of that, many are put to effective.
ಮುಗಿಸೇ ಬಿಡ್ತೇವೆ ನಾವು ಇದನ್ನ.
ಪೆನ್ಷನ್
ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಮುಗಿಸ್ಬಿಡ್ತೇವೆ. ಈ ಕಡೆನೋ ಆ ಕಡೆನೋ ಎತ್ಲಾಗ ಒಂದ್ ಕಡೆ.
ಪೆನ್ಷನ್ ಹೇಳ್ತಾರಲ್ಲ.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. Two advocates general are here.
Yes.
Aditya is also here in this.
Yes, Aditya is also coming.
He is also here.
We got disposal of one pension matter before quota number 3835, which dealt with the pension, the seeking of the pay revision for the purpose of pension revision. That batch matters has come. The question is whether the period what they have rendered in service.
Pre-aid period.
Yeah, that's what.
To be reckoned or not.
Or not. Whether for that part, that institution would be regarded as a state or not. That state. This is the latest judgment which dealt with this issue.
Unless that is aided, it will not be state. Till
Yes,
then it will not
yes,
be state.
that would not fall into Article 12. So the relationship between the employee and the management is private in nature. So the government cannot frame any service condition apart from the statutory provision. That is the judgment passed. We should dealing with all these issues. And
Whether it is state under Article 12 or not, is for the purpose of Part 3.
Correct.
How that question arises here?
This is in regard to the same, their service
They are not
condition.
enforcing any fundamental rights.
The service condition in regard to.
Service condition will not be a fundamental right.
Correct.
We are asking you, read Article 12, which says, unless the context otherwise requires.
Correct.
ಅದು begin ಆಗದ ಹಂಗಿದೆ.
ಹಾಗಾಗಿ.
ಹಂಗಾಗಿ ಪಾರ್ಟ್ 3 ರೈಟ್ಸ್ ಅಲ್ಲ ಅಂತಾರ ಅವ್ರು. ಅವಾಗ ಏನು ಉತ್ತರ ಕೊಟ್ಟ?
ಅವರ ಕಂಟೆನ್ಷನ್ ಏನು, ಆ ಪ್ರೈವೇಟ್ ಒಳಗೆ ಕೆಲಸ ಮಾಡಿದಂಥದ್ದು ಕೂಡ ನಮ್ಮನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತಕ್ಕಂಥದ್ದು. ಸೊ ಹೌ ದಿ ಗವರ್ಮೆಂಟ್ ಈಸ್ ಲೇಬಲ್ ಫಾರ್ ದಟ್, ವೆದರ್ ಇಟ್ ಈಸ್ ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ಅಲ್ಲ Lordship, I'll read these 3 lines and also the fact that all respondents as on the date are serving with the appellant society, they shall continue to serve on the terms and conditions as stipulated by the appellant society. So the same identical issue it is. We will demonstrate. We both are making research. We will come before that.
No, they had challenged a legislation.
Correct.
Legislation is struck down.
Then it is struck down. They are entitled to maintain the writ petition. They were entitled to, because it was against state action. State's legislative action. If that is so, then on that ground it has been allowed. They succeeded before the learned single judge, Justice Arvind Kumar, and another is
Mr. Shankar Magdam. Justice Shankar Magdam.
ಅವ್ರದ್ದು ರಿಟ್ ಪಿಟಿಷನ್ ಇದ್ರೆ ನೀವು ಹೇಳಿಕ್ ಬರ್ತಿತ್ತು.
ಹೌದು,
ನೀವು ರಿಟ್ ಅಪೀಲ್
ರಿಟ್ ಅಪೀಲ್ ಅದೇ ಅಲ್ಲ, ನಾನು ಔಟ್ ಆಫ್ ದಿ ಇದನ್ನ ತಂದಿದ್ದು.
State
Out of box I submitted one.
Anyway, ನೋಡು.
Finally, they will assist the court.
ನಿಮ್ಮ notes ಎಲ್ಲ
Notes, synopsis, list of dates, events.
You would need 4 weeks.
4 weeks.
4 weeks.
Previously, your lordship's opinion was that day by day basis matters. As your lordship's opinion.
We have very good opinion about everybody, but it keeps on changing. Same thing applies to cases also. We are accidental judges here.
Earlier,
Yes, we are in 4
earlier AG
cases.
has concluded his argument, and additionally AG wanted to conclude. That was the stage.
Let us see.
then an additional advocate general, so and so, both in part, and learned counsel for the respondents, Shri Janardhan and so others, request of learned additional advocate general. List this matter after 4 weeks to facilitate both parties to file a brief synopsis and assist this court. Call on after 4 weeks.
Lord, one submission, my lord. My lord, the impleading applications are there, my lord. Heard on impleading applications. My lord. We have filed the impleading applications. My lord.
Impleading applications in appeal.
Please, my lord.
Yes, ma'am. You were not writ petitioners.
Please, my lord.
Then how can you maintain impleading
No,
application?
my lord, writ petitions has been allowed, my lord, on the ground of subject to result of this writ appeal, my lord.
Yes.
We are impleading application on that ground.
Now, how you are now statute is set aside, quashed. If statute is reversed, now if judgment is reversed, the statute will revive. You will be beneficiary. Whether you are a part, why should you be heard? You are not the writ petitioner.
The writ petition has been allowed.
Alone, not your writ petition, others writ petition.
In my writ petition also allowed, my lord.
You are not made party here.
We are a party, my lord.
Then what is that impleading application?
My lord, implead for that effect to this appeal order, my lord. That's why, my lord, we have filed the impleading application. Number of impleading applications are there, my lord.
Nimnala here.
May I request for a date to be fixed, Lord, if it's not inconvenient? 14th March, Lord, would it be convenient? Friday, Lord?
14th March. 14th March is okay, Mr.
Brad, if it is by 16th, something like that, 2 days little later, if it is
For
possible.
21st, may I request?
21st. 21st. A list on 21st March. The impleading application shall also be heard along with the main matter.
Please, God bless you.
Oblige, Lord. ಇದು ಯಾವತ್ತಿದೆ ಬೆಳಗ್ಗೆ ಮುಗಿತದ ಏನು ಮಾಡಿ ಹೇಳ್ಬೇಕು ಅರ್ಜಿಗೆ ಹೇಳ್ಬೇಕು ಮಾರ್ನಿಂಗ್ ಮಾಡ್ಕೋಬೋದಾ
Yes.
ಮಾರ್ನಿಂಗ್ ಮಧ್ಯಾಹ್ನ ವಿ ಹ್ಯಾವ್ ಅನದರ್ ಬೆಂಚ್ ಅದಕ್ಕೆ
Yes.
ಆ ಡೇಟಿಗೆ ಇಲ್ಲ
If not on 21st, so that we can dedicate some time in view of
whole day for this case.
Yes, your lord. Because 21st, my lord has another bench.
Yes, any date convenient to the court.
One date. For that, some date, any other date.
Thursday.
27. 27.
27? All right.
Yes.
All right, finally, ಅವತ್ತು argue ಮಾಡಬೇಕು.
Please come prepared on.
Yes. Great.
Much
Court officer,